Good afternoon, and welcome to the Appellate Division, First Department. I'll begin with the call of the calendar. Please note that we currently have 6.5 hours of requested argument time. So there's a lot of you smiling because you know the drill. Please ask for the time you need, not the time that you want, understanding that the court is fully familiar with your case, the briefs, the record, oftentimes more than you wish we were. So understand that the time is for you, not for the court. So if the court has additional questions beyond the time, I let it roll, all right? So if you're brilliant, you'll get more time. All right. First case on the calendar, People versus Nelson Gonzalez. Submit. Maderos versus 147 Amsterdam. Okay?
Respondent 5.
5 and 1 and 5. Tommy versus Shamika is submitted. Laura versus Manhattan Interiors.
Appellant 2 and 1.
Okay.
Morning, Your Honors. Respondents request 5 minutes.
2 and 1, and let's do 4. Okay. Nationwide General versus Gaines.
Appellant 4 minutes.
Okay. Let's do 3 since you are unopposed. Okay. Riverdale Jewish Center versus Brooklyn Union. Okay.
And on behalf of respondents, we'd like to split our 6 minutes, 4 and 2, between all respondents and like a two.
I'm sorry.
I'm the cross appellant, Your Honor.
Okay.
So 2 minutes for the cross appellant.
Okay, and 4 minutes for,
For all respondents.
got it. 4 and 2. All right, so 5 and 1, 4 and 2. People versus Danielle McCreary. Submitted. Philadelphia Indemnity versus Addison PHS Corp.
Valentina Lecce, 3 and 2, please.
Okay,
Respondent Addison 2.
all right,
Respondent Newgrange 2.
okay. Oh, and plaintiff insurance is not here? All right, so 3 and 2, 2 and 2.
Thank you.
Indian Harbor versus Shuff Steel, submitted. People versus Joel Pizarro, submitted. West Pierre Associates versus Harvey.
Appellant request 7 and 4.
Okay,
Respondent request 7.
all right, 6 and 2 and 7. Itty versus Cella.
Appellant 7 and 2.
Okay,
Respondent 7, Your Honor.
7 and 2 and 7. Ormand versus Weinstein.
There are 3 appellants.
Officer, let her in, please.
There are 3 appellants. We have 15 minutes each.
That's what you've requested. Now, let me hear what you'd like. Thank you. Okay. Oh, no. Okay, so we're going to do 5, 5, and 5, and 10. Okay? People versus Leonard Jackson.
Good afternoon, Your Honor. Ben Shop Center for Appellate Litigation. I have a pro hoc vice introduction today.
Oh, okay.
Benjamin Harris of the law firm of Latham & Watkins. He'd like to participate in the proceedings pro bono today on behalf of Mr. Jackson.
Okay, did he submit briefs? Of course. Welcome, and thank you for your pro bono service. Okay, and how much time would you like?
7 and 2.
Okay,
Good afternoon, Your Honor.
good afternoon. 5 and 1 and 5. Wallik versus Wallik.
Appellant 4 and 2.
Okay,
And respondent ATS 5,
4 and 2 and 5. Okay, first case on the calendar, Maderos versus 147 Amsterdam. You may proceed.
May it please the court, Glenn Kaminsky with Morrow, Lilling, the party counsel for the appellants. I'm respectfully here to ask this court to reverse the decision that granted the plaintiff summary judgment under Labor Law 240. The circumstantial evidence of this case does not allow a court to grant summary judgment as a matter of law. This case is not Falker, it's not Angamarka, or any of the cases cited by the plaintiff in the briefs.
So, counsel, doesn't case law currently kind of hew against you? In kind, the tilting or the collapse of a scaffold is prima facie evidence of Labor Law 241 violation. And I could go on to give you like 4 more.
No, I think we addressed those cases in our reply brief, the kind, nudie, all those cases are factually different than the case at bar. There's nothing here, no evidence in an admissible form that would allow the court to say, this is what happened with this scaffold.
Wasn't there testimony, however, that the scaffold and the plaintiff were both on the floor, like the scaffold tilted over? Someone said it fell on top of him or it was on the ground, but it was on its side regardless.
There is, and that's Rosario's testimony, and a lot of
No one contradicted that testimony. Not one single piece of evidence contradicts the fact that this scaffold fell over. Not one.
And I don't disagree with that.
Okay, so then
Because-
under our case law, how do you survive that?
Because we don't know what fell first. We don't know that the
It doesn't
plaintiff
matter.
fell. Oh, it does matter.
Oh, no, it doesn't.
It does, because if the plaintiff didn't fall because of a violation.
Counsel, you've been here before, so you know how this works. You're not supposed to talk when the court is talking. Of
course, Your Honor.
Okay? So we know that even if there are times, and we have plenty of case law, where someone is on a scaffold, it becomes unstable, they fall first, and then the scaffold falls on top of them. That is a 240 sub 1 violation. So I'm not sure where your theory is going, but I want to go to the heart of your theory, which is that the circumstantial evidence here is not sufficient. We have a coworker who is in the room right next to him, simply with his back turned to him. And he says he hears a loud thud and turns around and sees the scaffold on the floor and the plaintiff on the floor underneath the scaffold. Why isn't that enough?
Well, why? I'll tell you why. Mr. Rosario, that's whose testimony you talk about, hadn't looked at the plaintiff in 20 minutes. That's what he's
I
testifying.
need you to talk louder, counsel.
I'm sorry. He didn't look at the plaintiff for some 20 minutes before, okay? And what he testifies, his belief at the accident, was not a result of the scaffold moving. It was a result of the plaintiff having some kind of medical event, a fainting event, and it's not pulled out of whole
How is
cloth.
that's not speculative?
No, it's not, because here we go. We have no basis to say the scaffold fell first.
So let's talk about
What we
latch.
had-
You keep on
and-
saying that,
and
so
how
you
we
have
know.
ignored what I said earlier, that it doesn't matter.
It does
Either way,
matter
counsel, what
if
we're looking at is the adequacy of this safety device. If it falls, it's not adequate. I think our case law is very clear on that.
But if he didn't fall because of the inadequacy, if he fell first, which he
So, counsel,
he may
stop
have
one
because-
second. Stop 1 second. So let's talk about latchkey, okay? A 2005 case where the court held, where we held, even if the plaintiff's medical condition may have caused him to faint or become dizzy, the plaintiff would not be the sole proximate cause of the accident. That's case law. How do you get around that?
Well, I get around it with Hernandez, which we cite in our brief, that raises questions as to whether there's intoxication here.
Let's talk about
Yeah, let's
intoxication.
talk about that.
Let's talk about it. So you do know the difference between milligrams and grams, right?
I do.
Okay, so you cite his blood level, his blood level was 0.019. The BAC level is 0.08. There's a difference between 0.019 milligrams and 0.08 grams, right?
There's a difference.
So-
And
what-
one
and what would
makes
that
you
difference be?
intoxicated and one isn't.
Yes, but it doesn't matter because,
0.019 is not intoxication, not even close.
but it does weigh towards having under the influence and imbalance.
Under what case law? This is real interesting. Under what case law?
Wouldn't that be
This is a-
comparative
you know,
negligence? And under our jurisprudence in 240 sub 1 cases in this state, comparative negligence is not a defense to a 240 sub 1 liability.
100% agree with you. And you know what? I can set aside the alcohol.
Well, we have to because it
And that's fine, because we still have sole proximate cause issues. I was looking at this case, working with an attorney.
you'll be
who
able to
said-
give me this argument on rebuttal.
Thank you, Your Honor.
Okay.
May it please the court, my name is Jeffrey Pesky with Vute, Lorfink, McAndrew, and Meisner for the plaintiff.
So counsel, what do you say in response to your adversary's position that it matters whether or not plaintiff fell first off the scaffold or the scaffold fell first, or does it not matter?
Of course, it does not matter. That means that the safety device failed. And they have two theories. The second of the two theories is created by the attorney sitting here next to me, that perhaps he lost his balance and on his way down grabbed onto the scaffold and they came over together. Well, that still shows the scaffold failed and was insufficient device to provide the safety, prevent him from falling, even from someone that became dizzy.
And that's not a theory absent actual evidence that could be put before a jury because it's complete speculation.
Correct. No one testified to any type of medical event except for Mr. Rosario, who speculated that he might have had a medical event. And then a follow-up question on that was,
Mr. Rosario being the coworker?
he was the manager for the...
He was the manager?
The tenant.
He doesn't have an MD.
No,
does
he was the restaurant owner.
Correct, the tenant.
Yeah.
Then I asked him a follow-up question at the deposition. Well, how do you know he had a medical event? Did you see any evidence of a medical event before the accident? No, I did not. So now, that's just pure speculation. And they've had access to all the medical records to see if there was a heart attack or a stroke or anything like that. Nothing was submitted because there wasn't any evidence of
So would it be speculation to say, well, how about if he intentionally jumped off?
Well, that would be speculative as well. There's no evidence that he intended to jump off the scaffold.
As if there's no evidence of what happened, right? What we have here is we have him on the floor and we have the scaffold on top of him. That's all we have.
No, you have a lot more than that, Your Honor. You have Mr. Famia that testified that it had defective wheel lock, or didn't have brakes. Then you have Mr. Castillo, who testified that it had defective wheel locks or inactivated wheel locks. He didn't know one way or the other. Then you have Mr. Rosario, who didn't know whether the wheel locks were working or not. You also have Ramona Ramos, who testified that the scaffolding didn't look quite right to her, and she is the tenant and watching the construction work, and she saw the scaffold and said, it didn't look quite right to me. It looked wobbly. It looked unsteady. So with all of that, and she continued to allow him to use it. In fact, 2 days before the accident, she overheard a conversation with my client and another worker saying, you know, I don't think the scaffold's set up properly. You shouldn't use it. She overheard that conversation. And she did nothing about preventing him from using the scaffold in her restaurant.
I just want to correct myself. Rosario is an employee of the restaurant, not the actual owner of the restaurant.
Correct. He was titled at one point as a manager for the restaurant.
Thank you.
Any other questions, Your Honor?
No? Thank you.
Thank you very much.
Counsel,
Counsel.
I'm going to give you his leftover time.
I
since we
appreciate
cut
that.
you off so much.
Let's talk sole proximate cause, right?
Go ahead.
Okay. Plaintiff bought the scaffold. Plaintiff set it up. He placed it. He worked on it for 5+ hours. He was responsible for the wheel locks, per Mr. Castillo, page 726 of the record.
Is there any case that says that a worker who sets up the scaffold, somehow that breaks the chain of liability and responsibility of the owner and the GC?
I think here, where he is the only person.
No. Tell me what case says that.
Well, I think we extrapolated from Blake and all the other cases about sole
Blake
proximate
certainly
cause.
doesn't put an
But-
onus on a worker. No, it doesn't transfer that responsibility. It doesn't.
I respectfully say that in this case, where he's the only person, who else was to blame but him? He's the only one doing it. I want to make 3 points, okay? One about the unsteady. We look to Mrs. Ramos about the scaffold being unsteady. This is the only testimony about unsteady, and it's pure hearsay. Page 388 of the record. So there's nothing about that. Let's talk about wheel locks. The only thing plaintiff gives us about wheel locks is at 321 of the record, where he says they don't exist, okay? Mr. Castillo, first of all, disagrees and says these scaffolds do, 730 of the record, they do have wheel locks, that plaintiff would be responsible for putting them on. Again, a scaffold with wheel locks that plaintiff didn't use, that's plaintiff's fault. But more importantly, plaintiff, first of all, is asked about the wheel locks and this Rosario testimony, and what he does is brushes it off. He doesn't say, oh yeah, I moved because it moved because of lack of wheel locks. There's nothing about.
He doesn't know one way or the other was his
He
testimony.
doesn't know one way or the other. No, we don't know. He may have jumped off the scaffold, pulled it down on top of him. We don't know. And with the credibility issues, the inconsistency issues of this plaintiff, where we know he lied about the permit, we know he lied about drinking alcohol, we know it's inconsistent with the wheel locks amongst all the testimony, we know it's inconsistent about the railing with all
Counsel,
the
your
testimony.
use of the word lied, are you exaggerating perhaps? Doesn't this person suffer from severe cognitive deficits as a result of this fall? Aren't you overstating your case in that regard?
Not on alcohol, because there's a.
The alcohol is a zero. It's a zero. It's a .019. So,
But it
really.
does show up on his medical records 2 hours after the accident. He has alcohol in his system, and he was asked directly, 321 in a record, were you drinking? He answers no.
I know you don't.
Got it.
You mustn't do DWI cases.
Thank you.
Thank you, Your Honors.
Laura versus Manhattan Interiors. You may proceed, sir.
Good afternoon, Your Honors. May it please the court. George Epstein, Meade, Hecht, Conklin, and Gallagher for defendant appellant Cameron Remigio. The trial court's decision should be modified, and the cross-claims against defendant Remigio for contractual indemnification and failure to procure insurance should be dismissed. The trial court properly found defendant Remigio was not negligent and properly dismissed the plaintiff's primary claims against.
Counsel, could we deal with the easiest case first? The easiest issue, the failure to procure insurance?
So, Judge, with respect to the failure to procure insurance, I would say that the alteration agreement did not require the shareholder to procure the insurance, but rather it was the contractor who was supposed to procure the insurance. And with respect to the indemnification clause provides, if requested by the board, the shareholder shall procure a bond or an agreement from an insurance company acceptable to the board, ensuring performance by the shareholder of the provisions of this paragraph. So I would say that that paragraph shows that the insurance is only required by the shareholder if it's requested by the owner defendants under that provision, whereas the other insurance clause refers to the contractors that the shareholder is hiring and not to the shareholder himself.
Okay.
Returning back to the indemnification issue. The trial court, I would say indemnification does not apply because the may I continue?
Finish your thought.
The indemnification doesn't apply because the indemnification clause requires Remigio to indemnify the owner defendants for its own negligence, and that's invalid under the GOL.
Okay, was there that language that, to the extent permitted by law, contained in the writing?
So, Judge, there was a savings clause in it. However, the respondent actually argues in his brief on pages 2 to 3 and page 16, it says Here, the indemnification is limited to the fullest extent permitted by law, and as such is limited to defendant Remigio's own negligence. However, the trial court properly found that Remigio did not have any negligence, so even if the savings clause does apply, then there's still no indemnification.
There was no appeal from that particular finding.
That's correct, Judge.
Thank you. You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Ross Frischer for owners' respondents. Before we get into the merits of the arguments presented by counsel, we have two threshold issues here. One is that the appellant failed to annex the alteration agreement to his moving papers and likewise can't meet his prima facie burden for that reason. The second point is that the appellant's arguments on appeal were not discussed at all in his moving papers. There's no reference to the general obligations law, and you can see, I'll refer you to the legal argument section there in the record at page 22 and 23. It's just not discussed, so these issues.
Based on our precedent on this issue, though, why wouldn't that be something that the court could consider just as being something that's evident from the papers?
Well, because, Your Honor, if you don't annex a copy of the contract, this court has very clearly held that you can't meet your prima facie burden from that. And I have a case, Crutch v. 421 Kent Development, LLC, 192.
I have your papers.
Thank you, sorry, Your
Okay.
Honor. If you're gonna, if this court considers the merit of the arguments, the indemnification clause does not violate general obligations law 5-321.
Okay, but what about his other argument that in light of the court's finding that Remigio had no negligence attributable to it, then the same result occurs, right? There can be no liability.
Well, Your Honors, I'll refer you to a case, Ballardus v. Southgate Owners. I'll just quote that quickly. An indemnification clause may be enforced where the party to be indemnified is found free from any negligence and its liability is merely imputed or vicarious. So even...
So tell me what vicarious liability there is here.
Just as the owner of the premises, he could be held liable for the actions of the contractor, and that's why...
As a residential homeowner, I don't think so. Not under 240, not under the labor law.
Well,
When it's a residential, when it's for your own residence.
Well, Your Honor, on that point, there was actually no determination of liability with respect to the owners and with respect to anyone else.
Yes, but you're not dealing with the determination of the court with respect to this party.
With
respect to this party, the court said they're not liable.
And no one appealed that.
yes, that's not
So that's the law of the case.
right.
Right,
But
so you're
even-
stuck with that now.
Yes, but even still,
Even still what? The court said he's not negligent. You just said that to the extent permitted by law means that he's only liable to the extent of his own negligence. If the court has already said he's not negligent, then he's out.
well, to your other point that you mentioned before, the motion court also said that there was an obligation to procure insurance.
That's what I want to know the answer to.
Yes.
Your adversary said that it was not the shareholder's obligation, but rather the contractor's obligation to procure insurance. Is that correct?
No, Your Honor. I'll refer you to page 568 of the record. Paragraph 2, and going into subsection D, it says, the shareholder agrees as follows: to obtain from each contractor hired by the shareholder, and then it goes on to next page, insurance policies. So it
So
was,
you just said, get from the contractor.
the shareholder had to make sure that the contractor procured the insurance.
Okay, so if you enter into a written contract that requires the contractor to do that, why hasn't the shareholder then satisfied their requirement to contractually require his contractor to get insurance? I don't understand.
So
Did the contract say you have to receive proof of it before work can begin?
it said that they had to deliver proof of that to the owner.
Okay.
So that would be us, and
And did the owner object?
Did the owner object to the?
So,
No.
most condominiums, a worker can't get in unless the doorman or the co-op, whichever, doesn't matter, co-op, condo, same thing. If you have a doorman at the building and they know that apartment 17C or whatever is supposed to have rental work, it would seem that it's incumbent upon the board to say, don't let any contractor in because we haven't gotten the insurance.
Before the work starts, that.
Right.
So I
So
think.
what did the owner do to make sure that they had the insurance?
Well, that question of liability on the part of the owner and whether he was, responsible for that is one to be fleshed out more fully at trial.
Okay.
That wasn't discussed here, and I just want to mention one more thing. The case Besios v. Regent Associates, which the presiding justice and Justice Rodriguez sat on, 214-83rd 554, when an indemnity clause is coupled with an insurance procurement provision, a tenant is obligated to indemnify the landlord for its share of liability. And you can't, again, I showed you in the record where that is, so I'll rely on my brief.
Thank you.
Your Honor.
Okay. You have 1 minute.
Thank you, Your Honor. So with respect to the threshold issue that the GOL was not raised in the papers below, that's not correct. I don't have the record citation off the top of my head, but I do know that the respondent brought it up in his opposition papers, and we brought it up in our reply papers. So
And the court addressed it.
yes, Judge. So it was definitely discussed below. With respect to the issue of the prima facie case not being made with submitting the alteration agreement, I would say for that, there's a lack of preservation on appeal because in opposition, there was no argument made that a prima facie case wasn't made. The alteration agreement was submitted. So the owner defendants did not argue in opposition that a prima facie case wasn't made. They only argued that there was a question of fact based on the alteration agreement. And had they not submitted the alteration agreement, then maybe I would be in more trouble than I am. But they submitted the alteration agreement
And so you
accompanied
can
with
rely
an
on it.
affidavit.
Right.
So I don't think the court is required to ignore what's properly in the record before it with respect to that issue.
Thank you.
Thank you.
Nationwide General versus Gaines.
Good afternoon, Your Honors. May it please the court, Brian Kaufman, Hollander Legal Group for Nationwide Plaintiff Appellant. Nationwide requests that this court reverse the lower court's denial of Nationwide's motion for summary judgment based upon the failure of defendants Addison to appear for an IME. The lower court held that plaintiffs failed to timely and properly request verification in the form of an IME within 15 days of receipt of the claims.
There's no time period implicated here at all because you served them before you got the...
That is correct. And this court has recognized that in Fogel v. Progressive, that the time limitations in 11 NYCRR 65, 3.5, and 3.6 do not apply when an IME is noticed pre-claim. And that was the facts herein. And as it happens that the second IME was requested timely within 10 days of the failure to appear for the first IME, and then the court secondly held that the denial was untimely. That's simply incorrect. The denials were issued within 30 days of the second failure to appear for the IME, and the claims were properly and timely handled. But even if they weren't, the court has recognized in Unitrin v. Bayshore that a denial premised upon a failure to comply with the condition precedent to coverage does not need to be asserted in a timely denial, as the policy can be voided ab initio. So if there's no questions, then I'd rely on the papers.
Thank you.
Thank you, Your Honors.
Riverdale Jewish Center versus Brooklyn Union et al. You may proceed.
Good afternoon. May it please the court. Gang Chen from Sussman Godfrey for plaintiff appellants.
You're going to have to bring that mic down so we can hear you.
How's that, Your Honor?
Much better.
Here, 3 defendants concede that plaintiffs are correct and that their customers were erroneously charged under their own tariffs.
But the issue is whether the court has to decide it as opposed to the utility PSC or LIPA because of primary jurisdiction.
That's the issue, Your Honor. And as to those three defendants, there's nothing for the PSC to decide. The defendants concede that plaintiff's
So I need
interpretation
you to
of their...
talk louder, please.
Can't hear you.
Those three defendants concede that plaintiff's interpretation of their tariffs is correct. There is no need for the PSC's specialized expertise in tariff interpretation because there is no dispute.
There's been another case where your client has been the appellant, decided at the end of last year by this court, where we discussed primary jurisdictions. How does that come into play here?
Respectfully, Your Honor, that case does not dictate the result here. The doctrine of primary jurisdiction, as this court has said before, is based on the circumstances of each particular case and whether the primary objectives of the doctrine, which is the need for the agency's specialized expertise and the need for uniformity, are served under those circumstances.
What about the filed rate doctrine?
Respectfully, Your Honor, the filed rate doctrine simply does not apply in this case. That doctrine comes into play when a plaintiff says, all the rates in the tariff don't apply to me, or that the rates in the tariff are wrong, and I want the court to come up with a new rate that I think is reasonable to apply to me. So that there are two concerns with the filed rate doctrine. There's the discrimination concern, the justiciability concern, excuse me. Here, we don't challenge any of the rates in the tariff. The residential GRT surcharge is fine, but it just needs to be applied to residential customers. All we want to do is be treated the same as any other non-residential customer and be charged the
So counsel,
non-residential surcharge.
that's where the expertise of the agency is arguably most useful. So if we take a hard look at this, each of the plaintiffs and each of the utility companies is differently situated with respect to the gross receipts tax, right? The GRT. And from what I understand, the plaintiff religious institutions want, because they are non-residential, they want to pay the tax that a residential customer would pay, which is their option, right? But then they don't want to pay the GRT with respect to what residents would pay. They want to go back and be treated as non-residents. So with the GRT, the residents would pay the higher rate at 2%, and the non-residents would pay the 0% rate. So it's obviously beneficial. But don't we need the expertise of the PSC and LIPA as far as saying, well, for example, we do this all the time. You don't have to choose chocolate or vanilla. You can choose chocolate and vanilla. You can be a non-resident and choose resident for one thing and non-resident for the other, as opposed to, no, we never do this. You choose one option and that's it. And then once we get that result, then we, the court, can review it.
So again, as to three defendants, Your Honor, they agree that plaintiffs have interpreted their tariffs correctly, so there's nothing for the PSC to decide there.
It's not a question of interpreting the tariffs correctly, it's a question of their application. And you're saying they should be applied in a certain way, and they're saying not.
As to those three
So
defendants,
that is
they-
precisely what the agency should determine in the first instance, so that this court has a full record to review.
As to those three defendants, Your Honor, the defendants agree that the tariffs are being applied, the tariffs should be applied the way that plaintiffs say they should be. As to the remaining 5 defendants, we've got some defendants under the jurisdiction of the Public Service Commission, one defendant, LIPA, not under the jurisdiction of the Public Service Commission. So if we apply the doctrine of primary jurisdiction, which remember, one of its primary objectives is uniformity, what we've got is one agency deciding some issues, LIPA, which is not under the jurisdiction of that agency, deciding the issue itself, and we could have competing results as to the same issue, which is whether the GRT tax, that's the same statute that is cited in every one of these defendants' tariffs, works the way the plaintiffs say it does. In contrast, if the claims stay with the court, we have one adjudication, one result, no risk of inconsistency.
I don't know about that, but I'll hear you later.
May it please the court, Francis Bivens from Davis Polk and Wardwell, representing Con Edison and Orange and Rockland Utilities and arguing on behalf of all the respondents.
So, counsel, are we talking about here some interpretation of the reasonableness of the rates, rules, and practices that might have primary jurisdiction under the PSC?
Yes, so this case requires the interpretation of the different tariffs that apply to each of the utilities at issue here. Each utility.
She's saying there's nothing to decide. You all agree that their interpretation is correct. There's nothing to go to the agency for. Why is she wrong?
Because each of the utilities has a different tariff, and one of the issues that the Public Service Commission needs to address is consistency across the utilities as to this issue, so that ratepayers in the state of New York are treated in a way that is consistent regardless of where they reside or which utility they're served by. And the Public Service Commission is in the best position to both address the consistency issue across all of the 8 utilities, but also to implement any remedies that the Public Service Commission deems to be appropriate under this circumstance.
And then that doesn't necessarily mean that it's without judicial review, because once they've utilized their primary jurisdiction, if there is another issue in terms of that particular interpretation, then that's when it's properly before this court or a court.
That is correct. So the motion court stayed the case pending consideration by the Public Service Commission, by LIPA, and if necessary, the Department of Taxation and Finance. And that was stayed for the purpose of the court then retaining jurisdiction so that there would be court review after the relevant agencies are able to weigh in and provide a consistent application of the tariffs and a consistent application of how the remedies should be implemented.
There's differing remedies available, am I right?
That is correct, and different utilities are differently situated with respect.
Is that a problem?
I think it's actually something that makes it particularly appropriate for the Public Service Commission to come in. So different utilities may have different abilities, or it may cost the utilities. Some utilities have computer systems that are more sophisticated than others. That's really what this comes down to. And the question is, how expensive will it be to identify a religious customer who has chosen a residential service rate but wants to be charged a non-residential GRT? It may be easier for that kind of separation. You choose one, as Your Honor was pointing out, you choose one category for your service. You choose a different category for your GRT rate. Some utilities may have the ability to press a button and achieve that result for their customers. Other utilities may have to do manual processes or other kinds of more labor-intensive and costly analyses. And so the Public Service Commission is going to need to look at the situation of each of those utilities and come up with a consistent application of what rules should apply and how it's implemented with respect to its customers.
So am I right, if I'm hearing you correctly, what plaintiffs are complaining about, the ability to have these 2 different rates and these 2 different classifications within one account, basically. That is permissible now. That is the way it should be now, correct?
Different utilities have different tariffs. So for example, the Bishop Loughlin case that we've cited and provided to the court is a case in which the Public Service Commission was asked about the tariff that applies to National Grid. The tariff on its face allows National Grid to charge any customer that chooses residential gas or electric service. It allows them, on the face of the tariff, to charge them also the same, the residential GRT, regardless of whether the customer is actually a residential customer or not. And so in that instance, the Public Service Commission affirmed National Grid's ability to operate in that fashion, which is different from what Your Honor just described, which is actually treating each of those categories differently. So the Public Service Commission really does need to look at the fact that there are different tariffs applied right now, different tariffs for each of the different utilities, decide whether it's appropriate for there to be consistency in the state, and then for each of the utilities make a determination about how to implement any change that's necessary if there is one.
And finally, on this record, based on what you've described, This court does not possess the necessary information of all 8 utility companies, nor do we possess the special skill and expertise in this area to do that assessment. And we don't have the power to make policy on this issue.
Exactly, Your Honor. I think that this actually requires some public policy determinations, and those are most appropriately done by the Public Service Commission.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Versacelli for the respondent, cross-appellant, Long Island Power Authority. Your Honors, on behalf of LIPA, it is our contention that all of plaintiffs' causes of action and claims against LIPA are barred by the filed rate doctrine. Therefore, rather than staying the action, the Supreme Court should have dismissed the amended complaint against LIPA based upon the filed rate doctrine. I think this case clearly is a case where the filed rate doctrine applies. It's broadly construed. It bars any claim that in any way seeks relief based upon rates on file. It also applies to classifications, practices, and regulations affecting such charges. We believe that the plaintiff's claims here violate the filed rate doctrine because the only injury alleged here stems from the payment of a filed rate. In the case of LIPA, application and payment of the residential tax cost surcharge. They also seek a refund of a portion of the filed rate.
But counsel, isn't that a secondary issue? Isn't the first issue whether the rates are appropriate, whether they're rational, I don't know, arbitrary, capricious, whether they're within the agency's jurisdiction and so on? You're saying based on the filed rate doctrine, bar the claims because they attack agency-approved claims, rates, sorry.
That's correct, Your Honor, because they attack agency-approved rates and charges.
But the issue here is, again, it's not the rate, it's the applicability of which rate for the GRT and for regular service. So I have to push back. I don't think it's about the rate. I think it's about the application of which rate.
Respectfully, Your Honor, that's correct, although the filed rate doctrine bars any claim that seeks a refund of a portion of a filed rate. And it's clear here, the compensatory damage that they seek are the difference.
So you're saying that even if a party can show that they were charged the wrong rate, the utility is able to keep that windfall?
No, Your Honor, if they're challenging the rate, then yes, it's barred by the filed rate doctrine.
No, if a party challenges the application of the proper rate, and as a result of that challenge, a court says you charged them a higher rate than you should have, and therefore they paid too much, they're not entitled to a refund of that difference?
That's correct. It's barred under the filed rate doctrine, Your Honor.
I don't know about that, but we'll see. Okay, thank you.
Thank you, Your Honor.
All right.
So I have to admit, Your Honor, I was a little surprised to hear from my colleague that this case is about computer systems. There's nothing in the record about computer systems. This case is here on a motion to dismiss. There's nothing in plaintiff's complaint about computer systems. And I have to say, I've never heard of a breach of contract claim where liability and damages depends on whether an agency thinks that the defendant might need more money or less money to fix its computer systems. Frankly, the only thing at issue here...
That's not what I heard, but okay. If that's how you heard it, that's not what I heard.
The issue here is simple. There is a tariff provision that all defendants agree imposes a surcharge that is meant to recoup a tax that those defendants pay. The tax that those defendants pay depends on whether they made sales to non-residential customers or to residential customers. none of the defendants dispute that plaintiffs are non-residential customers and that the sales that they make to non-residential customers is subject to the surcharge. Yet 5 of the defendants say, but actually, we are allowed to charge these non-residential customers the residential surcharge. I don't think it takes a specialized agency expertise to say that interpretation of your tariff does not make any sense. And we know that the PSC doesn't have the expertise.
Do you want to
because-
address your adversary's arguments that that the agency needs to make assess the different tariffs across the different service providers in order to do an analysis of their different tariff regimens and schemes and make sure that they're all consistent and following the law as the agency believes it should?
I was a little confused by that argument, Your Honor, because my adversary said that all the tariffs are different, but then said that the PSC needs to make sure that all the tariffs are consistent. So I'm not sure which one it is.
I think she meant the application of the rule has to be consistent, so that what I heard was that there are companies that if you pick a residential rate, then you're going to get stuck with the residential GRT, and that's the way they've set up their tariffs, and that there are other companies that don't have it set up that way.
Respectfully, that is the disputed issue in this case. And if you actually look at the tariffs, the language is very similar amongst all of the defendants. And the PSC has said that it can't interpret that very language based on the tax law that tariff provision cites because it cannot interpret the tax law. And so the question is, why would a court ever defer to an agency's reading of a contract that is that artificial and that incomplete?
Thank you.
Thank you.
Philadelphia Indemnity versus Addison.
Good afternoon, Your Honors. May it please the Court, Jerome S. Holiner, President Rosensky and Kuttner LLP for Appellant Team Electric, Inc. In a nutshell, Your Honors, the lower court's order denying Team Electric summary judgment should be reversed. The fact of the matter, the cold, hard fact of the matter is that the subcontract that Team Electric entered into with Newgrange did not in any way, shape, or form require Team Electric to install plumbing equipment, and in particular, the flood master leak detection.
No, but it required you to power up that equipment.
That is not the claim here. The claim here is that the equipment was not
The
installed.
claim is that you were supposed to install electric power so that this leak detector could work.
There are 13 leak detection systems that were part of this project. They are not the installer. The installer is, what the installer does is specifically defined in the plans. If you take note, the only place the flood master leak detection system is referenced is in the plumber's subcontract, where the plumber said, I will furnish but not install.
So then why isn't that an issue as to who had to install it?
To Team Electric, it doesn't matter who has to install it. It's not in its subcontract to install. And let's be clear, even admitted by Newgrange, electrical subcontractors provide power for, not to or of. That's all they do. If you were to hold any other way, every piece of equipment, device, or system that is put in a construction project, you would then turn the electrical subcontractor into the installer of that.
I really love when attorneys come into this court and try to warn this court how we're going to just explode and open up the gates of litigation with our rulings. I
apologize, Your Honor.
I love that hyperbole.
I apologize, Your Honor. Maybe a little carried away. The fact of the matter is if Newgrange wanted Team Electric to install this device, it would say so in the subcontract that it entered into with Team Electric.
So let's say I agree with you that the language is not the most perfect description of who's supposed to do what. But why isn't there an issue of fact based on the record we do have?
Because it's referenced in the subcontract, the plumbing subcontractors subcontract.
And it's
correct?
also referenced in, it also references the electrical work that is required for this to be installed.
But it was not installed. That's the position, and they only do electrical work. They're not responsible for
So,
installing.
counsel, having looked at the documents again and again and again, I have more questions than not, and this is a motion to dismiss. This is a motion to dismiss where there's a disparity as to, in essence, what the meaning of installation is.
That is not. That is, it is specifically written in the plans what the meaning of installation is. And it's the installer who has the duty to make sure that it is hooked up, complete, and ready for use. That is in all the plans, whether it's in the plumbing plans where this is identified as plumbing equipment, and for the electrical portion, the electrician has to do his electrical.
You're actually fortifying what I'm saying.
I disagree, Your Honor.
Of course, of course.
You'll have time on rebuttal.
Thank you.
And tell us who you're arguing for.
Yes. Good afternoon, Your Honors. Matthew Cuter from Lewis Brisbois on behalf of Respondent Addison. I'll be very brief. This case involves a floodmaster. Counsel's own affiant says that they were supposed to provide power for leak detection equipment.
But
It's
that's
designated-
power for the leak detection, not installation of the leak detection.
They were supposed to wire and make sure they had power. Plaintiff
How do you
alleges
do that if it's not there?
the leak detection was there. It was furnished. There was an invoice.
It was, but
Installed?
The leak detector was there in place in the
No,
drip
that's not my
plan.
question. Was it installed?
There's a specific.
there's a difference between, here's the box of the detection equipment. Somebody do something. That's different than, here's the equipment, I've attached it to the heater, now electrician power it up. Which is it?
Your Honor, plaintiff specifically alleges in their bill of particulars
Can you
that
answer my question? Which is it? Was the equipment attached to the heater? Because I would assume.
Yes.
Yes, it was physically attached to the heater.
it was in the drip pan, yes, and that's specifically alleged by
It was
plaintiff.
in the what pan?
It was in the drip pan of the hot water heater, yes. That was
I
specifically.
don't know what that means, but when I read
Yes,
the papers,
the
what I
answer
took
is
from
it
it
was-
was,
it
hold on a
was-
second, Counsel, I'm speaking.
I'm sorry, Your Honor.
I don't know what that means. When I read the papers, my understanding was that this leak detection system was not installed. Is that wrong?
Counsel is.
Yes or no? Is it wrong?
I'm not able to answer that in a yes or no.
That's a problem.
Your Honor, there is a specific definition for installation in the papers. That's what counsel is trying to argue. The leak detection piece of equipment.
Well,
But
let me
wait,
ask you, maybe you can answer this question then. Can you just point into the record where it clearly and unequivocally states that team was supposed to install this leak detection system?
In the electrical plans, it states that Team Electric, which was supposed to wire up and provide power specifically to the LD
See,
equipment.
I want you to stop because you're talking real fast, like we're not going to hear what you're saying. Power up is different from install. Okay? I've done renovations in my house too, more times than I care to remember. There's a difference between those two things. So either that piece of equipment was attached to the water heater, and I don't know what kind of water heater has enough space in the drip pan to put a leak detection system in it. You usually don't have anything in a drip pan because water falls in a drip pan. So I don't understand your argument at all.
If I may, Your Honor.
Yes, please. Please explain to me.
The Floodmaster is like a little piece of equipment, and essentially it just closes a valve. So it was attached to a piece of pipe in the drip pan.
And it was attached?
It was attached, and the allegation is that Team Electric did not properly wire it so that it had power so that it could operate.
Okay, all right.
Do you have any further questions for me, Your Honors?
So, may I ask you?
Yes, of course.
So it is your understanding, at least certainly from your expert, Mr. Fidelow, that this is really a team effort, that, no pun intended, team had to work with the plumber, so when the plumber did what you just described, they had to power up, and because they didn't do so, that's why they're in this case.
Consistent with the plans, the plumber was supposed to furnish it, put it on the pipe. Team Electric was supposed to wire it up. So
That's what your expert said in his affidavit.
Yes, yes.
That sounds like two people were involved in the installation.
Well, my client.
The plumbers had to attach it to, right? Because they're not a plumber, right?
Plumber did attach it.
Okay.
The allegation is that they didn't
Can I
wire it.
ask one last question?
Sure, go ahead.
Is there an allegation in the papers that the hot water heater was installed horizontally instead of vertically? And if that is so, did that make any difference here?
That does not make any difference for the floodmaster issue. That is a separate allegation that plaintiff makes against my client.
Okay.
Okay, all right.
Thank you, Your Honors.
May it please the court, my name is Michael Kazoris on behalf of the respondent Newgrange. Your Honors, I don't have the citation to the exact page in the record, but when Newgrange awarded this job to Team Electric, it did so in an email in which it assigned the job to, quote, furnish and install power for HVAC equipment and hot water heaters. I agree with what counsel for Addison said, and I believe Addison's president said in his affidavit that...
Counsel, page 165 of the record, if you want to know.
Thank you, Your Honor. Addison was responsible for furnishing the leak master detection system. They did furnish it. They did install it. The problem was it didn't work. It wasn't properly powered up. And the allegations are, in this case, both by the plaintiff and by the defendants that are averse to Team Electric, that Team Electric did not properly power this up. And respectfully, the documents that Team Electric produced in support of its motion, I believe, raises more questions of fact than they eliminate.
And we haven't had depositions yet?
Correct.
In this particular, so presumably, at a later time, this might become an issue.
Right.
With a fully developed record.
Exactly. And Team Electric didn't even supply an affidavit from its own foreman, Delroy Farrell. It didn't supply an affidavit from its own expert, whereas Addison provided the affidavit of Alan Fidello. It provided an affidavit from its president. It's clear that even if they met their prima facie burden, which they didn't, the respondents raised sufficient issues of fact in opposition to raise a triable issue to warrant denial of the motion for summary judgment. So for that reason, the decision and order of the Supreme Court should be affirmed. Thank you.
So what we didn't hear from Newgrange is its interpretation of the contract with Team Electric. Contracts are to be given their plain and unambiguous meaning. Nowhere in Team Electric's contract does it say that it had a duty to install the flood master leak detection system.
What about the email that they're talking about, this furnish and install portion?
There is no furnish and install. Team Electric...
That didn't actually make it into the contract.
That's an incorrect statement. And to also incorrect, the hot water heater and the leak detection system, they're two wholly separate and distinct pieces of plumbing equipment. There are 13 leak
How do you know that?
detection
Aren't you the
systems.
electrician?
What? And as an aside, my grandfather was a plumber. I learned to sweat at a very, very young age.
Touche.
I also learned how not to mix up the hot and the cold.
But counsel
which
is...
he did in my parents' house.
Counsel, is that what you just said, is that basically the gist of the affidavit provided by Mr. Anastos from
Yeah, he
Team?
goes through chapter and verse, what there is.
And isn't that in direct contradiction to what the engineer for Addison says, Mr. Fidello?
Mr. Fidello was not a party to the contract between Newgrange and Team
I'm
Electric.
talking about the technical stuff. Isn't there a contradiction as to what installation means and what wiring means and what components were affected?
Absolutely not. The plans dictate, and they specifically and concretely say...
Which plans? You mean the
both
conceptual
electrical plans and plumbing plans.
Yeah, when I'm talking, you have to be quiet.
I'm sorry.
Thank you. Are you talking about the conceptual electrical plans and the conceptual plumbing plans or other?
I apologize.
Or other plans?
The conceptual plumbing plans specifically indicate that this particular leak detection system, this floodmaster leak detection system, is plumbing equipment. It specifically indicates that it is to be installed by whoever is doing the plumbing scope of work. It is not Plumbing is not electrical work. Electricians provide power for everything. To a disconnect point, they do not provide power to or of. And as indicated in the briefs, if they were to provide power to or of, that could lead to catastrophic circumstances. If they were to provide power to something that is not yet operational, and then it went into operation, bad things could happen.
Counsel, I may regret asking this question, but I'm going to ask it anyway. Was the leak detection system installed?
It was not. By definition, it was not. Under the terms of the conceptual plumbing plans, it was not installed. Whoever knew Grange.
Now you're making the distinction between it being installed, whatever the definition is, as opposed to it was present.
Furnishing is just what they agreed to do, which Addison agreed to furnish it. They said, furnish it. That's what's in their contract, and that's what...
But furnishing, we don't mean I received the leak detection system and it's in my office.
No,
It's supposed to it's on the pipe where it should be.
In this particular instance, it just means they delivered it to the site. That's what it means.
All right.
And they declined to install
Counsel, your time is up.
Thank you, Your Honor.
And the more you talk, the more issues of fact I hear. So
Thank
have a
you, Your
good day. West Pierre Associates versus Julia Harvey.
May it please the court. Good afternoon. I'm Seth Miller from Collins, Dobkin, and Miller. I represent...
Lower that mic so it's right by your mouth so we can...
I represent appellant Julia Harvey.
Okay, can we agree on certain facts here? Your client's counterclaim for overcharges was in 2022, correct?
Yes.
Okay, which makes this a post-HSTPA case.
Correct.
Prospective.
Right.
Fair enough?
Prospective, that's exactly what we're saying.
And as I understand on the record, your client has no issue with any of the calculations per se. Just bear with me. With any of the calculations, what she takes issue with is she wants to look back to 2014 when there was a vacancy and where certain AIs were installed for approximately $36,000. And 7 years later, when she files her counterclaim to not paying rent when she unilaterally decided not to in this non-payment proceeding historically, she's taking issue with all that work being done, correct?
She's taking issue with the IAI that doubled the rent.
That's what I just said.
Between 2014 and 2015.
And again, so we agree. So where, under the HSTPA, with the exception of having a 6-year statute of limitations, requires the law, where is it required that we apply, I'm sorry, I'm going to restate it. Why can we not apply the standards for rent increase for apartment improvement that predate the 2019 HSPTA?
Because the HSTPA applied prospectively requires that all available rent history be considered, and because the applicable base is not a base date but a base registration, the registration filed 6 or more years prior to the most recent one, which would be the 2015 registration embodying those IAI increases. The HSTPA places that registration statement squarely at issue and makes that available for challenge to any tenant.
How did you challenge it?
By filing an answer with a counterclaim saying these...
But you offered no. They made a motion for some... They were able to competently prove, based on the evidentiary record here, that they had invoices, receipts, checks, to justify the $36,000. I'm rounding it off.
Well,
you have only offered speculation.
No, that was not a summary judgment motion, Judge. That was a 3211 motion claiming that we didn't state a claim for.
Well, that's my point. So what did you, what kind of allegations, what kind of facts, short of saying it doesn't look like an improvement, did you throw in there?
Well, it's not just it didn't look like an improvement. They claimed that there was a hardwired
smoke detector. My client pulled it out of the ceiling and it had batteries. They claimed a new
Counsel, this is also your client takes possession of this apartment about some 7 years later, and after other tenants had been in the apartment, correct?
Yeah, but no claim was made of any renovations between the 2014 renovation and my client's renovations. So that, based on the record that we have, should this be remanded and go to trial, we will have our expert testify about the state of those renovations. As we expect the owner to be able to call their contractors to say whether, since they haven't proven that they did any work at all, they've only proven payment but not actual work, we expect our contractors to come forward and say what they did.
So, Counsel,
But there's plenty of evidence that they didn't do what they say they did.
So, Counsel, in looking at the photographs and the documentation provided by your client, it seems like her concerns could be characterized as concerns emanating from shoddy workmanship or poor quality materials as opposed to the lack of a renovation. And you ask...
I don't see how it could be construed that way.
Well, when you show...
Counsel?
When you show a picture of a closet where it's separating at its juncture, it looks like it could just be cheap closets, and that's the end of it, as opposed to the failure to actually install closets.
Well, what the landlord had said
And I mean kitchen
in their
cabinets.
in the voluntary production that they made was that they removed the closet. So all my client wanted to say is, no, we have a closet. It's present. It's an actual closet. They didn't remove the closet. We weren't saying anything about the quality of the closet.
There's no way that she could know that. She wasn't there when these renovations were done.
She knows
And
that-
she's there 7 years after.
She knows-
Wait, counsel, I am talking.
I'm sorry.
You keep doing that. It is disrespectful to the court. There's a thing called wear and tear.
Of course.
Right?
And I would just add to that there were at least 3 other intervening tenants in that time period.
We're not, the closet issue is, was there a closet installed or not? There was clearly a closet in her unit. The landlord had claimed it had been removed. That was an item on their itemized list. They claimed to have installed an entire new rewiring of the apartment. It was clear that they hadn't. They claimed that they hardwired.
How is it clear that they hadn't? Tell me how she knows that.
Because for one thing, they claimed that there was a.
I want to hear this answer.
Claimed that the smoke detector was hardwired.
What?
and
No,
it
no,
had a
no.
battery.
You said she claims there was no electrical work in this apartment. There's no evidence of that.
Yeah.
And unless she broke open the walls,
she did.
In order. You go ahead and talk because you obviously don't care what the court has to say. I have nothing else to ask you.
I apologize.
Go ahead, because I have, no.
Counsel, the problem that we have here is that, do you have any affidavits from an electrician who examined the electrical wiring in the apartment?
Not in this record.
That's a problem for us, right?
When you're opposing the summary judgment motion, right, you have to submit something that's going to raise a tribal issue of fact. What do you have other than these 5, maybe 6 pictures and her speculative assessment?
Well, it was not a summary judgment motion. It
Sure it was. They cross-moved for summary judgment.
Right.
The 3211.
No, it's 3212. And you first moved for discovery under 408. This is a summary proceeding. You usually don't get discovery right away as a matter of right. So they cross-move. So the issue is you can't use discovery to try and back into defenses if you don't have anything competent to oppose a motion for summary judgment.
Well, under 3212, if the facts aren't available, you can. You can ask for discovery in opposition to, in order to be able to.
Go ahead.
You could not have gotten experts to come in and actually look into the apartment and go through all the contracts and invoice that spelled out all the renovation work and go check, and then put in a competent affidavit by such an expert who said, I inspected and I find ABC, even making allowances for wear and tear over the 7-year period. You didn't do that, sir.
You'll have time on rebuttal. You'll have time on rebuttal.
Thank you, Judge. Good afternoon. May it please the court. Rose and Rose by Paul Copy for the respondents.
I have a question as to discovery.
I'm sorry?
I have a question as to the discovery
Sure.
demands that have been made. This case is situated in the housing court, right?
That's correct.
Is there normally discovery provided in housing court?
Discovery is not available in housing court as of right. It can be obtained by motion on a showing that the party moving has a viable claim that there is information or evidence within the exclusive possession of the opposing party that's necessary to support the claim. There are various other factors involving mitigation
So we know
of
that
prejudice.
we know that if it's a gut renovation, itemization of the repairs that were done is not generally required, right?
That's correct, yes.
So was this a gut renovation, and was itemization required?
Itemization is not required in the case of a gut renovation.
Was it a gut renovation?
It appears to have been a gut renovation. Yeah, the work was quite extensive.
Does that define what a gut renovation is?
The DHCR guidance on that is actually pretty vague. But I would suggest the gut renovation would involve new electrical appliances, new fixtures in the kitchen, cabinets, flooring would normally be replaced in a gut renovation. Appliances would normally be replaced in a gut renovation. That's a rough description.
Thank you.
Sure.
Sir, this is not a situation where the apartment was deregulated, correct?
That's correct. It was not
The rent-stabilized tenant today. So
Yes, it's been
so
rent-stabilized.
all those cases that require looking back to determine the status of the apartment is not an issue, correct?
That's correct. Those cases.
And the evidence that you submitted, all those invoices and contracts and all that stuff, was consistent with DHCR policy?
Yes, that's correct as well.
Pre-HSTPA, correct?
That's correct, yes.
And we have case law, including case law from this court, that finds, in fact, where my learned colleague next to me was on that panel, the Segai case, just issued a short while ago, that basically acknowledged that this kind of evidence is competent to justify IAA.
Yes, and I'll go a step further because the questions for both of us tend to implicate the Boyd case, in which there really was no question that work was done. The tenant, without the benefit of any expert testimony, essentially challenged the value of the renovations on her conclusion that things seem to have come from a big box store. Justice Gish at the Appellate Division said that didn't even raise an issue of fact. The Court of Appeals.
Counsel, in your purview, or maybe from the law that's kind of been developing from this court, should we say that in order for a plaintiff or a tenant rather to raise an issue of fact, they need to have expert testimony? Would they be able to do that?
I'm not sure that needs to be a blanket rule. I think it's an appropriate holding in this case where the tenant herself ripped open the walls, took some pictures of essentially wires behind them, and concluded, without even alleging any basis for competent testimony on the subject, that the premises had not been rewired. There certainly will be cases where expert testimony is not required. I think, apropos of
the other issues as well. It's also a pretty black letter rule in discovery motions in housing court that discovery is not available for a party to find out whether they've got a cause of action. There's a fairly high threshold that has to be met.
The Farkas decision sets forth the criteria for discovery, doesn't it?
That's correct. Yes, yes, it did. There are subsequent decisions that apply the standard of you don't get discovery to find out whether you've got a cause of action. I did want to get at least a little bit into Regina because it's all over the papers. What the appellant is really attempting to do here, I believe, is to restore the burden of proof in this case to the landlord, to prove that IAIs not only were made but had a certain value. It's in fact, I can cite to the papers. It's at page 19 of the record, paragraph 40 of Mr. Miller's brief. His position is that IAIs are an issue in this case. They were made in 2014, and despite the fact that they were made in 2014, it's the landlord's burden to establish that not just that they were made, but everything needs to be itemized. There need to be checks to back it up. Applying the HSTPA, Mr. Miller asked in discovery for before and after photographs, something that DHCR required after HSTPA. There's no way that the landlord would have. Regina very specifically, I believe, rejects such an attempt at burden shifting. In any case where essentially, as of the enactment of the HSTPA, the landlord was not required to hold records. The HCR addressed this in amendments to the Rent Stabilization Code, 2526.7, the new post-Regina amendment to the code, where they basically said, if you have fraud, all bets are off. If you don't have fraud, you can't have a base date before June 14, 2015. Because, very simply, we're not going to impose on a landlord the burden of coming forward with evidence that they weren't required to preserve and that may very well not be available. That's okay. I'm out of time, I see. I'll rest. Thank you, judges.
You have 2 minutes on rebuttal.
Thank you, Judge. In addition to the closet and the hardwired smoke detectors, we were able to show that there was double billing in this record. We were able to show that some of what they were claiming was ordinary repairs, such as simple painting, sanding floors, and the like. Those raised a sufficient question of fact to proceed to a merits determination on the discovery.
So I was reading your concerns there, and the only thing that I kept coming up with is that, of course you would paint, of course you would sand, and of course you would finish. And your argument is, well, what, my client shouldn't have to pay for the painting and the sanding and the finishing? Is that your argument?
No, that those things don't qualify for a rent increase. I mean, of course, landlords paint and sand, but they don't get a rent increase for those things.
But you're challenging a rent increase that was in place a year before the base date.
There's no such thing as a base date anymore under the HSTPA.
Wow, okay.
The HSTPA applies prospectively. That's what most, as my colleague says, most of the briefing was about.
Okay.
The HSTPA applies prospectively, as the Regina case recognized and preserved. Regina says, quote, "We are not invalidating or striking down the overcharge calculation provisions in the HSTPA." And what the respondent wants to do, and what the court below did, was strike down the all available rent records provisions of the HSTPA. Those were stricken down not by the Court of Appeals in Regina. Those were stricken down by the lower court in this case. And it's up to the legislature to say what the rent is going to be following the effective date of the HSTPA.
Thank you. Edie versus Cella.
Good afternoon, Your Honors. James Schwartz from Coca Marino for Plaintiff Appellant Eli Edie. This case has been dismissed on a statute of limitations basis. Court has to remember that this comes up in a very interesting procedural posture. 4 years after the sale of the party's building, they voluntarily agreed to arbitrate the matter. Years later, and I should add that in that arbitration, each was making affirmative claims against the other. You owe me millions of dollars, and back, you owe me millions of dollars.
So what is clear, Mr. Schwartz, is that in their statement of claim against you,
yes,
and even in their answer against your statement of claim before the arbitration in 2016,
yes,
there was not a single affirmative statement claiming that any of your claims, such as breach of fiduciary duty, unjust enrichment, and et cetera, are time barred, correct?
Correct. And they knew about this because in a...
But that doesn't matter.
I agree with you, Your Honor.
You are required to assert any claims or defenses when you agree to arbitrate. The fact that your client was not required to, once he submits himself to the jurisdiction of the arbitrator, now he's stuck with whatever is decided. He can't go through the process, expend all of the resources and money that it took to litigate that for years, and then say, I don't like the decision, I changed my mind, I wasn't even supposed to arbitrate, so now I'm going to assert, years later, the statute of limitations.
Your Honor.
That's Cella, right? Who's making that claim, the statute of limitations.
Cella raised the statute of limitations issue 6 years
In
after.
other words, you're agreeing with everything that my colleague just said.
I'm not a judge, Your Honor, but I concur. I concur. Completely concur.
And in between that 6-year period, there was document exchange, and it wasn't dormant. It was actually active.
It was being actively litigated. Document exchanges, depositions, and expert reports. The reports are so extensive that we didn't put them in the record because they were thousands of pages long.
This thing is trial ready, practically.
That is correct. And
now let me ask you. So what your adversary is saying is that by putting you on notice, and I guess the arbitrators, that they're objecting to your discovery demands for anything that was time barred. That's enough. Why isn't that enough?
It's not enough for a couple of reasons, Your Honor. You have to actually assert. You have to actually assert it as an affirmative defense. And in addition, here, while it was asserted in response to some document demands, my adversary then produced the documents that were supposedly objectionable, thereby undercutting the matter.
They did reserve their right.
Well, it's not really reserving the right. It's an interesting point, Your Honor. The cases that, as I read them in my brief, seem to say that you can't be a cutie pie about this. You've got to, you can't put it in your back pocket and see what happens. And this is
I think the CPLR says the same thing, right?
Yes, it does. But you can't decide, again, the critical thing here is that both sides were making affirmative claims against each other. It's a strategic use of the limitations period. Strategic use. That's condemned in the case law, because what it really means is, I'll assert it if I think I'm going to lose, and I won't assert it if I think I'm going to win. That's not what should be done here.
The truth of the matter is that if they truly believed that your claims were time barred, then even before they even went to arbitration, they should have gone into court to get the claim dismissed. Correct?
Precisely,
and they didn't do that.
That is correct, Your Honor, either under 7503, under 7502, and indeed, they could have raised it in front of the arbitrators under CPLR 7502B. So could have raised it.
So, counsel, as to paragraph 4 of the arbitration agreement, it says that the claims and counterclaims interposed in let me read it from the beginning. Notwithstanding the date of the filing of the summons and verified complaint that was to be filed prospectively,
Yes.
the claims and counterclaims interposed therein shall be deemed filed as of the date they were filed in the arbitration. So what does that mean relative to your argument?
Well, it means that the statute of limitations is not mentioned there, and in fact, in the agreement that transfer the case from the arbitral panel to the court, basically the parties limited themselves to what had been before the arbitral panel.
Well, counsel, let me just ask this question because there was a July 15, 2016 response to document demands where there was an assertion about relating claims that were related to applicable statute of limitations have been expired. Does that change your position or argument at all? Why not?
It doesn't change. It doesn't change anything because that goes to whether they were going to use it. That goes to it goes actually against them because it shows that they had knowledge of the purported statute of limitations claim, but were deciding whether or not they were going to come back and use this thing. If they were going to lose the arbitration, look at this. We put it into a document demand. If they were going to win the arbitration, there would have been radio silence about it.
You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Heath Olnowich, Olnowich Law, PLLC, for the respondent, Cella.
So, counsel, just picking up that thread and referring back to that July 2016 assertion in that demand where you referenced the statute of limitations, but then for 6 years after that, nothing comes of it. It's never mentioned again up until we were dealing with it in this particular context. How do you explain that?
Sure, Justice Pitberg. And this goes to the waiver issue, obviously. Regarding the discovery responses, the statute of limitations defense was put in there. And
Where?
It was in the responses.
In that one sentence?
I'm sorry, Your Honor?
In the discovery response?
It was put into the both discovery responses early in the arbitration in July and October of 2016.
Why wasn't it asserted as an affirmative defense, which is what you're trying to do now? What if you're trying to assert it as an affirmative defense as a bar to this claim? And again,
sure,
when you are in arbitration, if you don't raise a claim or an affirmative defense, it is waived.
The problem, Your Honor, is that as Justice Barak found in the Supreme Court, the parties were not given an opportunity to assert affirmative defenses or even—
6 years you were in counsel. If you take the time in your discovery response to say, what was it, the exact language? That it's not subject to said objections and without waiver, I don't understand why that would not have been prime opportunity for you to assert the defense.
Well, the defense is stated in the responses, Your Honor, but importantly, the court below found, and this is accurate—
What case law says that you can assert an affirmative defense in response to discovery request? And that secures your affirmative defense? Tell me what case held that? Because I can't find one.
Fair question, Your Honor. I'm not saying that there's case law that says that asserting a defense in a discovery response preserves the defense, but CPLR 7502B would have allowed the arbitrators, had this continued arbitration, to consider the statute of limitations defense at any time.
Counsel, did you raise the statute of limitations fair and square to the arbitrators and say, what are we doing here? You know, we have a statute of limitations problem.
No, Your Honor. And the reason is because...
And you're saying that it's the arbitrator's responsibility to make arguments for you?
No. What I'm saying, Your Honor, is CPLR 7502B allows us, right? It allows the arbitrators to consider the defense at any time during the arbitration. The problem is that once there was a conflict with the arbitrators...
Counsel, you know, if this had been transferred in 2017, maybe that argument would have some teeth. This got transferred in 2022.
That wasn't by choice, Your Honor.
Okay, which meant that for 5 years, you're before this arbitrator, and you say nothing to assert this defense. So the parties, we should hold that it is okay for counsel to hold an affirmative defense in their pocket and allow parties to litigate for years and years and years and years and waste everybody's time, only to end up with a quick dismissal because this is a clear statute of limitations problem.
That's not what we're arguing, Your Honor.
That's exactly what you've done, though.
What
And why should we sanction that?
Respectfully, Your Honor, we would have raised it in the arbitration in a summary judgment motion had the arbitration continued, but the case law...
Counsel, had it continued, but it continued for 6 years. That's the whole point. I'm looking at 7502, and it doesn't help you. It talks about making raising the statute of limitations as an issue, and then it says the failure to assert such bar by such application shall not preclude its assertion before the arbitrators who may in their sole discretion apply or not apply the bar. We're going in circles,
Correct,
which
but-
is to say you had to be a protagonist.
Respectfully, Your Honor, that is correct, but we had planned to raise it in a summary judgment motion in the arbitration. It was not because
Is there
of...
anything preventing you from asking the arbitrators to rule on this in advance, considering that it's dispositive?
I've never heard of a case where you can get the case dismissed in year one, but you opt to spend money litigating for 6 years instead, and then wait until it gets transferred to another court to assert what you could have asserted in the first instance, and again, not wasted the resources of the arbitrators and now of the courts.
Can I make 2 points on that, Your Honor?
Please.
Number one, the case law is to the effect in this department, the second department, and the third, that even where there is an alleged waiver, if the summary judgment motion raises statute of limitations and the opposing party has an opportunity to substantively defend against that motion on the merits, summary judgment on that defense is still proper, even though it wasn't raised. There are cases that say 5 years, 6 years is not too long. The second point I might make, and I
Did
realize
any
my
of those
time is...
people win?
I'm sorry?
Did any of those people win? You're saying that there's a parallel situation where parties were engaged in an arbitration, one side failed to raise statute of limitations considerations, and then subsequently was able to raise them in Supreme. You're saying that that's happened before, that there's a precedent here that we're missing, or that maybe you missed?
No, what I'm saying, Your Honor, is this is a unique case, as counsel pointed out. I was not able to find, and counsel hasn't cited any cases where the case started as an arbitration and then was transferred to Supreme Court. What I'm saying is that the case law allows that even...
That has happened before. What hasn't happened is that an affirmative defense of statute of limitations wasn't asserted in the arbitration and then gets asserted in the court after years of litigation and arbitration. That hasn't happened before. Nor should it ever happen again.
I understand that. I understand what you're saying, Your Honor. What I'm saying is that the case law is that when you have the case in the Supreme Court and you make the summary judgment motion, as long as the opposition is able to substantively oppose that motion, summary judgment on the defense is still proper. And can I make one more point?
But this is gamesmanship. Counsel, this is gamesmanship. This is gotcha.
It is not gamesmanship. Respectfully, Your Honor, we would have raised that in a summary judgment motion before the arbitration. The reason that we switched from arbitration to Supreme Court...
You didn't have to wait for summary judgment to raise this issue, counsel. You didn't.
But under 7502...
You didn't have to wait to summary judgment to raise this issue. And you litigate for 6 years and don't raise it once.
But under 7502, Your Honor, respectfully, you're allowed to wait until summary judgment to raise it, and we put the plaintiff on notice of the defense early on in the case. May I make one more point?
No, done. We've gone on long enough. You got 2 minutes. Thank you. Ormand versus Weinstein. Who's gonna, for which company?
Just lower this. Good afternoon, Your Honors. May it please the court. I'm Loretta Lynch from the firm of Paul Weiss, and I'm arguing on behalf of Defendant Appellant Creative Artists Agency, or CAA.
Okay.
I'm here with my two co-appellants as well. So may it please the court. Again, Appellant CAA is here as part of this matter because of 3 fundamental and reversible errors by the motion court below. This is a negligence case, as the court is aware. Plaintiff Ormand has alleged against CAA a negligence claim arising out of harm caused to her by a third party, Mr. Weinstein, and she's also alleged to breach a fiduciary claim sounding in negligence as well. But the court made fundamental reversible errors. As the court is aware, in order to hold a party liable for harm inflicted by a third person, there must be under New York law, there must be a special relationship between the defendant and either the tortfeasor, some kind of control over that person, over the premises, or a special relationship with the person who's harmed.
So does a talent agent have a special relationship with his or her client or its client?
So that was an issue, that was the issue. And what the court below said was that the contractual fiduciary relationship, which is a term in the contract, what gave rise to the special relationship under tort law. And under New York law, that is not the case. The plaintiff is required to plead, but did not and could not below a special relationship outside of the terms of the contract. And that's because in tort, the special relationship, as I mentioned, governs control. Again, she would have been required to plead that CAA had some kind of control over Mr. Weinstein. That was not pled because it's not the case.
So with respect to the facts that are alleged, whereby Ms. Ormand was encouraged to meet privately with Mr. Weinstein, is that enough?
No, Your Honor, not in terms of a separate allegation of a special relationship under tort law.
Isn't that part of the contractual relationship to set up appointments with prospective or actual producers and so on?
As the court notes, everything the plaintiff alleges stems from the contract between the two parties. And again, there is a clause in there that describes that relationship as fiduciary in nature. But as the court has found repeatedly in a number of cases, where there's a contract, that governs. But if a party wants to raise a separate issue in tort, not based on, and it's not a breach of contract case, they have to allege a duty separate and apart from the contract. That's in the national.
So Ms. Ormand alleges that there was certainly sufficient, that CAA possessed sufficient information to apprise them that meeting with Mr. Weinstein privately is a dangerous proposition for women, and that prior clients of CAA, in fact, directly complained of precisely the same kind of conduct that Ms. Ormand complains of. Why does that fact not raise at least an issue of fact about whether that created a special relationship because they possessed information that she would have no way of knowing, and that they were duty-bound to share with her?
So, Your Honor, with respect to that issue, it doesn't create a special relationship because it's actually not information that was similar enough to what Ms. Ormand unfortunately suffered. I think you're referring to the allegation that another young actress, Ms. Kirshner, was propositioned by Mr. Weinstein. This was, again, an incident that occurred a year before Ms. Ormand's assault.
Does it have to be exactly the same? I
It has
mean,
to be-
it seems to me that just if you have a 19-year-old who has told you, when I went up to the apartment, he basically tried to make my contract with him conditioned on sex, why that would not be enough for CAA to be very careful with any women that they encourage to meet with this man privately. Why isn't that enough? It doesn't have to be exactly the same.
So, Your Honor, that the plaintiff actually raises that to assert that there was foreseeability, which is only an issue if there's a requisite duty of care. And as noted before, and again, just to finish, just to make sure that I put that before the court, that's the Nassau Financial Federal Credit Union case, Clark Fitzpatrick versus LIRR. The tort, it can connect to the contract, yes, and there is a contract here, but the duty has to be pled and has to arise separate and apart from the contract here. And without that special relationship, this case has to be dismissed and the matter falls. On the issue that Your Honor is focused on, the foreseeability based upon what happened to Ms. Kirshner, again, another tragic incident, the law is clear that in order for that to rise to the level of foreseeability under negligence, it needs to be sufficiently similar. And certainly it was an awful thing for Ms. Kirshner to experience.
I don't think I agree with you on that, but you'll have time on rebuttal to try to convince me, okay?
Thank you, Your Honor.
All right. Who's next?
Good afternoon. If it pleases the court, my name is Marvin Putnam of Latham & Watkins, and I'm here for Miramax, specifically Miramax Film, New York. You were just discussing the various things that are required, Your Honor, in terms for the court to have
Just
held.
a little bit
Yeah.
louder, or maybe move
Oh,
closer.
I can
to
do
the
either. I can do either. When usually I'm told not to yell and to slow down.
Walk loud. Walk loud.
We talk loud. That doesn't
All right, I'll
bother
do
us.
that. It's good to be home. The issue. I also have three principal issues as to why the lower opinion was problematic and must be overturned.
Okay.
And mine go to the very issues that constitute how can you have a negligent hiring and supervision claim. And it's not enough to have just employment. But what the court found below was that employment was enough. In fact, to quote the court said, a connection between employment and plaintiff's injuries.
So let's talk about the apartments.
Yes.
And what's the relationship between employment and the apartment, which was provided by Miramax, where the assault took place or allegedly took place?
I have three different responses to that, Your Honor.
Please.
The first is, actually, the court below did not rely on that, nor is it part of their appeal. They did not appeal that issue, so I just want to note that. Second, Your Honor, even if it had been part of the lower court's opinion, New York law has been very clear that that would not be enough. And here's why. If you look at the cases like Osad and others that we have actually cited to, they talk to the idea of control. It's more an issue of control. Who controls what? So, example, in the Osad case, where the defendant owned the hotel, and that's where they were looking.
Look, if the argument here is going to be no one controls Mr. Weinstein, so none of us are responsible, that is not going to get the day, okay? So the issue is whether there were facts known to the different companies that put them on notice that there was potential danger to women actors, okay, in private proximity to this gentleman, okay? So that's the issue.
And just to add to that, in terms of the employment contracts that may be out there, why isn't it sufficiently pled? I mean, we're at the 3211 stage. Maybe we were in summary judgment, maybe we'd be having a different conversation. But at this particular juncture, why isn't the pleading enough, just asserting rather these employment contracts that maybe are in the possession of Miramax that might lend itself to some sort of detail?
So I'm going to answer all three of them, but going back to Your Honor. So what I would say is that you are 100% right. It goes to foreseeability. The idea of this exceptional duty, because it is an exception, goes to the idea, can you foresee this? And what constitutes foreseeability? So I'll just quickly finish the idea that if you look at the apartment cases, the building cases where there's a connection, that has never been shown to be enough. I want to note that first, okay? But I then move to the idea of what is knowledge in terms of,
Except that here, we have this just gold mine of a statement. When he asks her to go meet at this apartment, he says, let's go back and discuss this at the apartment that I'm paying for.
I agree.
So that absolutely brings Miramax in, because he is utilizing what Miramax is paying for as a means to pressure her to go back to this apartment. Why is that at this stage not enough?
I have two different answers to that, Your Honor, which will also go to your question, I hope, Your Honor. And what that is this. That's only one element. We must remember there are three important elements when you look at this, because it is an exception that go to foreseeability, and control is one of them. And I think what you're going to, Your Honor, is the idea of control, controlling that location. It also goes to the idea of premises and resources, the idea of chattels or how that is. It goes to that. But there's a third element of this, which is the idea of knowledge in advance. The idea that one knew that there could be a problem in a private location, as you noted when you were talking to my learned colleague. And there is no allegation of prior knowledge here, not a single one, Your Honor, which makes sense. It's hard to believe today.
Except for the statements that Miramax had already spent a fortune settling a multitude of sexual harassment and abuse complaints.
And actually, Your Honor, it doesn't say that. It says something close,
close
to that. And what it says, but the close is important here, because what it says is that his brother, Robert Weinstein, and he settled a matter together. It does not say that it was related to Miramax. It does not say that Miramax even ever knew about this.
That's why discovery is important.
Yes, but you have to allege, Your Honor, to get to that stage, and it's really important here. To get to that stage, there has to be an allegation. I'm not saying it has to be proven, but there has to be an allegation of knowledge. Excuse me, ma'am?
You're saying there's not enough.
Yes, not even close. I want to be really clear, Your Honor. I don't think it's even close. Because I think if you look at the various things, it doesn't once then relate that back to Miramax. And you must relate it back to Miramax. And you have to do it with what they knew then, which is terribly important. It's very hard from October of 2017 to today to look at this as what did they know then? Because on that point, when the New York Times came out with that article after years of investigation, there are hundreds of thousands of articles, newspapers, movies, everything about what occurred. And we look at it through that lens, but we have to look at it through the lens of what they knew at the time. What did Miramax know at the time? And there's nothing alleged that they knew it then. Nothing, not once.
Okay, thank you. And that would be in the possession of Miramax, so that only discovery would yield that information. There's no way that, let him up for one more second since I'm talking to him. Right?
No.
No?
No, and that's what I'm going to say. No, actually, Your Honor, interestingly, there's a point in our briefs where we talk about this, which is the Miramax that's been sued is an entity that came into existence decades later. You're not going to find it out from that Miramax. Yeah. There may be people who know.
That argument ain't going to work either. Sorry, go ahead.
May it please the court, David Korn of Cravath, Swain & Moore on behalf of the Walt Disney Company. I have a very different argument for you, for all of you.
I'm ready for you.
It is a veil-piercing argument, because that is the argument that the court below found compelling, and that is the only reason the Walt Disney Company is still in this case.
And that wasn't asserted.
And it wasn't an argument made below, correct, Your Honor. And that argument was error. It was error because neither of the requirements of veil piercing are met. It is a fundamental tenet of corporate law in this state. You have to have complete domination of the subsidiary, and even that is not enough, because the complete domination must then be used to injure the party that was wronged. There is no complete domination that was ever alleged, which is why the plaintiff never pressed that argument below, and there also never was any use of such complete domination to injure the party, because it doesn't make sense in this case. There's no allegation that Disney somehow had an evil mind, used this subsidiary to injure this party all the way back in the early 90s. It is just not a veil-piercing case. And once that error is corrected, credit the trial court. It did that because there just are not allegations in this case about the Walt Disney Company in one particular respect that I'd like to focus on, which is the property or resources requirement of Moore. We have a very clear direction from the Court of Appeals now about what is required for this tort, and it is use of the property or resources of the employer. So what are the property or resources that are involved here? There's all sorts of arguments that can be made about why no Miramax property or resources could be used. You have the argument about the apartment that goes, there's arguments on both sides of that. But if you read the complaint, there are no allegations about Disney property, no allegations about Disney resources.
So are you saying that the contracts of your subsidiary, Miramax,
Yes, Your Honor.
are not, cannot be utilized to connect you, Disney, to those actions?
Correct, Your Honor. I am saying that, and I'm saying in this complaint, the only contract that's alleged of Disney is an employment contract for Mr. Weinstein that Disney is alleged to have co-signed.
Counsel, let me just ask you a question, because in recent times, this court has held, in the context of the CVA, that because of this employee relationship and the process, the access rather to the injured party through that employment relationship, we have held that it doesn't matter if it did not occur on premises owned by the employer, but it was the access that was granted through that relationship. Does that matter at all in this case?
It does, because I read those cases somewhat differently. First of all, if you're looking for the standard, it has to be more. That's the standard in this case, that's the standard in CVA cases, and it says property or resources. Is it true that you can use property or resources of an employer off premises? Of course that's true, but that's not this case either. There are some cases that talk about, for example, in the church context, where there's someone who grooms the...
Why does the apartment not qualify?
Because it is, if you take their complaint as pleaded, which I do, it is a quote-unquote Miramax apartment. It doesn't say it's a Disney apartment. It doesn't say Disney paid for it. Harvey Weinstein didn't say Disney. It is a Miramax apartment. And I take the complaint as true. And if it is, Disney is not involved. And the motion court below, I think, accepted that. Because the motion court did not say, oh, I'm deeming this a Disney apartment. That's why it pierced the corporate veil, because that's the only way to get to Disney, and that was error.
Got it. Okay.
Thank you.
Thank you. All right.
Good afternoon, Your Honors. Kevin Mincer for plaintiff respondent Julia Ormand. I appreciate the court's careful attention to the case.
Counsel, I want to start with CAA
Yes.
and the special duty. How is that triggered here?
Yes. So as counsel was describing for CAA, a special relationship can be based on not just the relationship between the tortfeasor and the defendant, which is what we have in the case of Miramax and Disney, but it could be based on the relationship of the plaintiff and the defendant. And here, and the Court of Appeals has recognized that one of the ways that can be is if you have a position of special confidence and trust with the injured party. And that's exactly what is pled in this case. And what I have to take issue with, my colleague for CAA, she represented to the court that the entire complaint is based on the contract and what was in the contract. In fact, the contract is not even mentioned in the complaint. We supplemented the motion to dismiss record with the contract and gave the court some additional information. But the complaint itself goes through the nature of the relationship, the reliance that what Ms. Ormand was hiring CAA to do. If I could just take a step back. So Ms. Ormand, when she hires CAA, she's really, approaching the peak of the profession. And she's not looking for a talent agent at this point, it's fair to say, to tell her where to go to audition, right? She's hiring advisors. She's hiring someone to guide her career. And that's what is alleged in the complaint in paragraphs 9, 68, 96, and 97. I won't try to read them all, Your Honor. We don't have that much time. But the thrust of it is that she is hiring CAA to give her advice and to guide her. And that's exactly
She's
the kind
a foreign actress,
I'm sorry?
She's a foreign actress. She's from Britain.
She is from UK, Your Honor.
Right.
And that is the exact type of special relationship of trust and confidence that does create a duty of care under the case law. Now, the motion court, when you take those allegations as the backdrop, then on top of that is provided with a contract in which CAA agrees that they are a fiduciary And a fiduciary, under all the case law, is at least as a heightened level of rigor in terms of the relationship and what's required as a special relationship for purposes of tort law. So it's the combination of the nature of the relationship as pleaded, and the trials court is accepting the facts as true as pled in the complaint, and on top of that, the contract and this specific recognition that there's a fiduciary relationship, there's a recognition in that contract that they're not, I'm not trying to quote it here, but in substance, that they're not going to put her in harm's way, that they're not going to send her to a place where she's in danger. That makes this, I think, what the trial court said, not a stretch, right?
Is that a standard SAG contract?
Those provisions are the SAG contract that's incorporated into her contract. So that's part of the agreement here. Now, this goes back from 1995. I can't represent what the current SAG contract is, but that's what the record is before the court. So I think that in looking at this on a motion to dismiss, certainly 3211, we have more than enough to establish a special relationship with CAA. That creates the duty of care. So quickly then to turn to the question of foreseeability, which is what counsel also talked about. Your Honor was pointing out that there's obviously the specific allegation about Ms. Kirshner, and with respect to counsel for CAA, their papers really unfairly minimize what happened in that instance. That was not, I think that they described it as inappropriate behavior by Mr. Weinstein, but an inappropriate behavior is perhaps an off-color joke or something like that. This was a man who was leading a movie studio who tried to barter sex with a 19-year-old young woman. And so when CAA learned of that, the alarm bells should have gone off there, that this man was not fit to be working with their clients, certainly not young women clients. And they didn't do that, Your Honor. They took no interest in it. When as alleged, the complaint says that when this was disclosed to them, they said basically nothing could be done. And that's why we're here 25 years later with all these other allegations piled up, because
Do
they
the
said—
alleged statements and reactions by the CAA representatives who dealt with your client, do their comments in response to her reporting add anything to your arguments?
Absolutely, Your Honor, because it's not just a matter of that one incident. And by the way, just underlining there the nature of trust and confidence, right? Because she's telling her agents this horrible thing happened to her, this sexual assault. And when she tells them that, there's no reaction of surprise or shock or, oh my goodness, how could Mr. Weinstein done this? What she does get is all kinds of warning, discouraging her from going to the police, warning her about angering Mr. Weinstein, telling her that if she proceeds with this or talks about it, she might get sued for libel. And then to top it off, they suggested that, well, she could perhaps hire a lawyer and get a settlement, but it'd be $100,000, suggesting that they know the Harvey Weinstein playbook then. They couldn't have just picked $100,000 out of thin air, or at least that is a reasonable interpretation of the facts alleged in the complaint. And so you have CAA, when presented this whole picture, it's more than a sufficient basis to say that they knew or should have known that Ms. Ormand was in jeopardy.
Could you address counsel for Disney's argument?
Yes.
Disney had
Yes.
to do with this, but
Forgive me, Your Honor, I just couldn't hear the last thing you said.
your adversary said that Disney had nothing. That Disney had nothing to do with this other than signing an employment contract.
Okay, and then so I would very much like to address each of the elements. So as we talked about or as the court was talking about with counsel, the motion court did find Disney on the second and third elements based on a veil piercing theory. And that in total candor of the court, we said in our brief, we did not argue that below. But so the negligent supervision claim has essentially three elements. There's the employment with the control piece of it, and then there's the foreseeability piece of it, whether they had noticed, and then what we're arguing about here is we'll call it the resources element, right? And so the contract certainly with Disney, as alleged, right, it establishes that they had an employment relationship with Harvey Weinstein, and that along with Miramax, that they were both employers. And its employment contract, not only does we have the contract alleged with specific dates, we also have allegations in the complaint that the highest levels of Disney's executives were Harvey Weinstein's supervisors. He reported to them. So that's the definition of what control is. If you can supervise someone, you're directing their work, and you have the ability and the opportunity to direct what they do. Unfortunately, they didn't exercise that control properly, which is what we'll get to. So that element of the motion court's finding is really not having anything to do with the veil piercing. Now, the motion court on the next two elements for Disney did use veil piercing. I could, and we have in our brief, suggested that that is a defensible affirmative holding, giving deference to the 3211 standards, giving the benefit of plaintiff what's pled in here in terms of domination. But that's not what I'd like to argue to the court. What I'd like to argue to the court is that there's more than a sufficient basis to find that Disney knew or should have known without any kind of veil piercing. And we should look at direct claims before we look at veil piercing. And here, what we have is a set of allegations. Really, my friends representing Disney and Miramax really kind of minimize it, but we have a whole litany of allegations of what happened before Miss Ormand was sexually assaulted from 1990 to 1995. And several of the allegations have to do with knowledge of Robert Weinstein, who is not just his brother, right? He's also the co-chairman of Miramax, and, as alleged, an employee of Disney as well, like his brother. They both had the same arrangement as alleged. And so when counsel acknowledges that Robert Weinstein had knowledge of alleged incidents of sexual assault, sexual harassment that were settled, those facts are attributable or imputable, at least on a 3211 motion. Those facts are imputable to Disney because
Did Disney have anything to do with the settlements? Is there an allegation that they either approved or helped pay the settlements?
There's not an allegation of that, Your Honor. But what there is an allegation is we're talking about knowledge here, and his knowledge is imputed to Disney in this instance. So he knows that his brother, his fellow co-chairman, is dangerous and that he's engaged in this behavior. And so
You want us to say that because the brother knows, that automatically means that Disney has to know?
once he becomes their agent, Your Honor, that's the imputation that the law requires. So they could make arguments perhaps later on in the case that, oh, he learned of this in a different context. It wasn't in, whatever they want to say. But for purpose of the 3211, there certainly should be a fair inference that he knew this was going on. He was a Disney executive or a Disney employee.
I need you, before you sit down, I need you to tell me what evidence in the record there is of complete domination that would permit us to uphold the piercing the corporate veil finding.
Well, Your Honor, if the court does go to veil piercing, and let me stress, I don't think the court needs to, because I think there's more than sufficient basis as a direct claim against Disney. I think that you'd have to look essentially at what the lower court found, that there's in paragraph 13 of the complaint said during the relevant period, Disney exercised oversight and control over Miramax and Harvey Weinstein, including but not limited to paying their Miramax employees, controlling their budget, approving or vetoing requests for film budgets for Miramax, and auditing Miramax's books, reviewing and approving and paying business expenses of Miramax. Now, my colleague says that's all normal corporate supervision, but I think that fairly looked at here, when you're talking about paying employees, when you're talking about paying their expenses, and the direct supervision that we have related to Harvey Weinstein from Disney, and that's the allegation here. We have a domination, at least as to the transaction at issue here, which is the supervision of Harvey Weinstein, that is more than just the normal corporate supervision. If I may briefly, Your Honor, just address the resources issue, because before
I'm going to give you another minute.
Another minute, yeah.
You've gone on over the time.
I'll be quick, Your Honor. So on the resources of Miramax and Disney, this complaint is basically from beginning to end, tells what happened to Miss Ormand, and it's all about how Harvey Weinstein used the resources of his employment, right? And his employment, as we've established, is from Miramax and Disney. Collectively, these two companies gave him the power to run this movie studio and to use his authority to greenlight projects and to take meetings and then to pay someone for an apartment. And so the combined use of all of those things in this, as alleged in the complaint, leading up to the moments of the sexual assault of Ms. Ormand, okay, is from the employment that he was bestowed upon by both of these companies, and that's why they're responsible. Thank you.
Okay. All right, rebuttal time.
Thank you, Your Honors. I just want to touch on a few points made by my esteemed adversary, Mr. Mincer, with respect to the issue of the contract and that being the source or potential source of the duty. If you look at the complaint, there are numerous instances. I just want to point the court for reference to the most important one, which is on page 22, paragraph 96 of the complaint. And what it does is it describes CAA as Ms. Ormand's talent agent during the relevant period, and it outlines those duties and responsibilities. Had the responsibility to procure employment, other work opportunities, to negotiate favorable terms for those opportunities, provide advice about her career, and held itself out as having unmatched expertise. All of that is pursuant to the talent agency actor contract, Your Honor. So everything that is the source of, and then the complaint goes on to say that this is the source of the special relationship in paragraph 97. There are other places in the complaint that also describe the duties of CAA. They all fall under the terms of the contract. And that takes the court to the case of Clark Fitzpatrick, where the court was struggling with this issue of, are you looking at the contract? Are you looking at a tort issue? Because if it was a tort, you've got to allege a duty independent of that contract. And there the court looked at the actual issues that were being discussed and said, this is actually relates to the contract, so it's going to fall under contract pleading, and this other issue relates to a tort issue, a negligence issue, and so it's going to have to be pled according to the negligence standard. And that is what plaintiff has not done here. More importantly, the motion court just devolved everything into the term of the contract and said, because there's a fiduciary term in the contract, there's a special relationship. That is not the law in New York State. There's so many fiduciaries out there in terms of different professional relationships. If the lower court opinion stands, every single contractual fiduciary relationship automatically becomes a special relationship for the purpose of tort, particularly applying to a third party harming someone. On the issue of Ms. Kirshner, again, page 16 of the complaint, it's paragraph 69, it's only 4 sentences. And let me just say that there's no attempt to minimize what occurred with Ms. Kirshner, but in terms of the detail that's here, what is alleged is Ms. Kirshner goes to a hotel room with Mr. Weinstein. He offers to exchange sex for a career opportunity. She declines, and he leaves. There's no allegation that he touched her, mercifully. There's no allegation of a physical assault. There's no allegation of a sexual assault. And sexual harassment is clearly a different type of violation than sexual assault. Again, not minimizing how Ms. Kirshner felt, but for the purposes of pleading, and also, again, for the purposes of whether or not this established any kind of foreseeability, which we submit you don't get to if there's no duty, this is just not enough. Particularly where, if you're going to find a special relationship to protect someone against a third party, again, the element of control over the information, and the complaint is replete with pages where other people have allegedly specific knowledge of Mr. Weinstein, unfortunately, actually sexually assaulting young women. None of those people are CAA. None of that information is imputed to CAA. To infer that it goes to them is, again, not pled with the particularity required. I would just finish up, again, by saying that, as the court is aware, the plaintiff also pleads a violation of the fiduciary obligation between the parties, and the court below erred in saying that, oh, that's from the contract. Once again, tort law in New York says for a tortious fiduciary breach action, you've got to have a duty outside of the contract. Also, the pleading requirements under 3016B were nowhere near close to being met here. And for a breach of fiduciary duty, there must be an allegation of direct harm, not just proximate harm, on the part of the third party who harmed the plaintiff. That's nowhere in the complaint because it just didn't occur.
Thank you
Again,
so much.
thank you for your time, Your Honors.
Thank you. All right, you're next.
Let me just raise this up.
Speak loud enough anyway. Very quickly, Your Honors. I want to address several items that were risen in oppositions very quickly. One thing that we keep hearing is control, because that's the issue. Can you control him? Which goes to Your Honor's point of, don't tell me nobody could control this man, which I agree with. You can't say that. But what the court did below, and you have to look at the finding because it's so important.
I think you misunderstood what I said, but go ahead.
I apologize, Your Honor. Okay.
I meant the opposite.
I'm sorry. No, I don't.
I meant the opposite. It's clear Mr. Weinstein cannot be controlled.
Well, but
okay, and so I mean that to me is not the measure of control. It's not controlling him as a person. It's controlling his access to resources that.
Exactly,
Okay,
Your Honor.
right.
And I apologize if I just misspoke.
Okay.
I knew exactly what you meant.
All right.
I said it wrong just now, and I apologize.
All right.
Because where I was actually going with it, Your Honor, is precisely that, which is when I said no case has found that an apartment in this instance is a resource or goes to the chattels element, is because of the idea of dominion and control. Who has dominion and control over that space? And what the cases have shown, usually in a hotel context, because usually in these similar instances, is that they come back to my hotel room, and then it's being paid by another. But in that same instance, it's the idea of, did they have dominion and control? Who had dominion and control over that apartment? In this instance, I think it is clear from the pleadings, Your Honor, that Ms. Ormand had dominion and control over her apartment. It is never alleged, not once, that it's Miramax's apartment. At some points it says that it's hers. At other points he says, I'd like to see the apartment that I'm paying for.
So why isn't that enough to at least push this into summary judgment to explore that a little bit more?
Because I believe, Your Honor, that what it doesn't show is it doesn't even allege dominion and control over that. So it can't be the type of chattels or the type of resource that is controlled by someone that I can then control the person, in this instance, Mr. Weinstein, and his ability to go there. She controlled that.
Let me just ask you the same question that I posed to Disney, as in the CVA, where we have found that we can maybe, I guess, transfer that or maybe put it all together. I'm going kind of fast because the red light is on. In terms of things that happen off-site because of the employer-employee relationship and that part of it. Does that matter at all?
Yes, but I somewhat agree with my colleague, but I'm going to say it slightly differently. In those instances of the cases that I have read, like for the pastor case, I'll take as an example, the idea is it didn't happen at the church, but it did happen at the parsonage and at the, I can't remember what they called it, but it was a summer camp that he oversaw. And in those cases, there was still dominion and control and a continuation. Whereas in this instance, we don't have that, Your Honor. She reached out to him to meet. Miramax was not
He
involved.
reached out to him or CAC to?
She had CA do it, yes,
I mean,
Your
CA.
Honor. What I meant by that is Miramax was not involved in that. They got together, they didn't discuss work at dinner, they did not discuss work at the bar afterwards. They then talked about discussing work in the apartment afterwards. There is nothing there in terms of the linkage that I think is the same as those cases.
I mean, I don't know. I'm sorry.
Okay. I hope that answered your question, though, for my position, Your Honor.
It's fine.
And we can go in circles
Yeah.
for hours. Go ahead.
I will not do that to you, Your Honor. 30 seconds. For
I
the Walt Disney
appreciate
Company.
you. Thank you. Go ahead.
As a process point, I did not hear a vigorous defense of the veil piercing holding below, and I think that was correct. Therefore, I don't believe you need to do any more to vacate the judgment below and send this back and let the court below take a look at the allegations that actually are in this complaint. But if you are so inclined to look at them, you will see there is nothing about Disney property or Disney resources in them. And that's paragraph 41, 42, 45, 46, 49, where all the action is about where the allegations about what actually happened in this incident are. You will not see the word Disney, because there is no allegation that Disney property or Disney resources were used. That is enough to decide this case.
But there is Disney employment.
And Your Honor, I'm talking about the property or
I
resources.
understand that, and it's not that clear that premises and chattels, it must be a central element.
It is, Your Honor, I would commend you to look again at Moore. It is absolutely a required element now. Under Moore, it must be. It is number 3 in the case. It must be required. We're not contesting employment for purposes of today's argument. We do contest it in the briefing. I'd refer you there. But I'm giving you the clearest path to dismiss Disney because I think it's required.
Thank you.
Thank you.
Thank you all. People versus Leonard Jackson.
Good afternoon, Your Honors. Ben Harris of Latham & Watkins, appearing as pro bono counsel for appellant Leonard Jackson. May it please the court, I'd like to begin with the excessive sentence issue. There are three reasons why we believe this sentence should be reduced in the interest of justice. The first is that the people asked for a sentence of 10 years, but Justice Mandelbaum exceeded that sentence by 20% to sentence Mr. Jackson to a term of 12 years of incarceration. The second is that Mr. Jackson is a first-time felony offender, an offender who's never been convicted of a crime before this. The third is Mr. Jackson's personal circumstances support leniency in this case. He has no gang affiliation, a high school diploma, strong work history.
Counsel, I see your second point. This was a doozy for a first one, right? I mean, the injury to the face was significant, and then coupled with that is the whole threatening and the bribery. Doesn't that in itself justify the sentence?
2 points about that, Your Honor. First of all, on the issue about the bribery and the threatening, Justice Mandelbaum sentenced Mr. Jackson separately for those counts. Those don't go to the top line count of assault. So those counts were handled separately, given the maximum sentences to run concurrently. As to the first count, there's no doubt that Mr. Jackson committed a crime. It was the heat of the moment, and that it produced a lasting injury. But the prosecution knew all of that. They had all of that information.
That's another issue, because the prosecution, as you stated, recommended 10.
Right, and so just on the issue of the prosecution, Your Honor, obviously they knew about all those things and still recommended 10 years. And just to point the court to...
Are you suggesting that the court is bound by the recommendation of the people and cannot make their own assessment and judgment about what an appropriate sentence is and reject the recommendation of the people?
No, certainly not, Your Honor. The sentencing judge has discretion to go up to the maximum under the statutory...
and he didn't go to the maximum.
That's right, Your Honor. But there are cases, and we cite these in our briefs, in which courts, the Second Department, the Third Department, have recognized that when the prosecution recommends a sentence lower than the judge eventually gives the defendant, that can be grounds for this court to exercise its independent discretion, not deferring to the sentencing judge, to decide that the circumstances justify a more lenient sentence in the interest of justice.
So, counsel, to what extent do the injuries that were inflicted on the victim, how should we take those into account? This is a 40-stitch laceration on the face that is disfiguring, for starters, requires a lot of healing. Couldn't the judge have taken that into consideration, and should we?
Certainly, Your Honor, the sentencing judge took into account the extent of the injuries here, and in no way does Mr. Jackson want to minimize the extent of the injuries to the victim in this case. Our point is only that there's other circumstances here that are unusual and that warrant a more lenient sentence. And those include the fact that this is a first-time offender with no violent history of criminal offenses, and the fact that Mr. Jackson has family circumstances that here we think warrant a reduction sentence in the interest of justice. He has 3 younger siblings. He has a 9-year-old child. He has strong family ties, family who are here today. And Mr. Jackson has cared for those family outside of the circumstances of this case. So look, there's no doubt that the injury here was something that the sentencing judge could take account of. But again, let's just talk about the years that were on the table in front of the judge. The people had offered 8 years before trial.
I'm drawing a blank. Anyway, continue. I'll come back to you.
I want to ask about the threats that were made and the bribes. Could you address that?
Sure. Mr. Jackson...
And when you say, because you make a lot about the 20% increase in the number on the assault case, but by running the sentences concurrent on the other crimes, he got no time for that.
Well,
right? So the fact that the judge says, I'm going to run those concurrent, but I'm going to increase the number on the assault, what's wrong with that?
Well, Your Honor, the people did request a concurrent sentence before the sentencing judge.
I understand that. We have put aside that the court doesn't have to listen to the people. So that argument, you can continue to say it, but that doesn't win the day.
As for the bribery and the other charges, he was given the max on those. Now, I take Your Honor's point that the judge ran them concurrently.
Yeah, that's like a free ride.
What was the exposure?
You could have gotten consecutive time for that because those were separate crimes, not having anything to do with the underlying assault. And under our statutes, the court would have been completely justified in running that time consecutive, okay? So increasing the bottom line number on this very horrific assault doesn't seem to be so drastic as you painted.
Certainly, Your Honor, that there was discretion for the judge to go higher than the judge did. But here, the years on the table before the judge, it was 5-year offer from Justice Claude, a 6-year initial offer from Justice Mandelbaum, an 8-year offer from the people prior to trial, 10 years from the people after trial. None of those proposed sentences on the table.
So what are you requesting now? That we reduce to what? That's what I was drawing a blank on.
We think the appropriate sentence here, Your Honor, is time served. Mr. Jackson's been incarcerated for 5 years and 9 months.
That's probably not a lawful sentence, but in terms of a number, what would it be?
6 years, Your Honor. We think that aligns with what Justice Mandelbaum was originally offering the defendant.
Time served.
At this point, Your Honor, Mr. Jackson has been behind bars for nearly 6 years.
All right. You'll have time on rebuttal.
Thank you, Your Honors.
Good afternoon. May it please the court. Matthew Colangelo for the people.
Counsel, let me just ask you this question. Because of, just as how your adversary detailed the offers that were made pre-trial and then post-trial to impose, a 12-year sentence, could we look at that as it was maybe some kind of punitive sentence because this defendant chose to go to trial?
No, Your Honor, I don't think there's any evidence, and there's no indication in the record of the sentencing hearing at all that Justice Mandelbaum imposed any kind of trial tax. The justice explained in detail the factors that led to the sentence that he imposed. He was concerned about
any of the factors that the judge detailed that you did not consider in making your 10-year recommendation.
The judge identified the Rikers incident.
But then he said he's not basing it on that, right?
Correct. So no. The answer to Your Honor's question is no. The court mentioned that Mr. Jackson had armed himself with a weapon, was quick to resort to violence in the incident on February 5th, the charged event. But no, the people considered these factors and made the recommendation that we made, and it was well within the court's discretion to impose a slightly higher sentence in light of the gravity of the offense, the lifelong lasting seriousness of the injury that Mr. Vasquez suffered, and of course what the judge characterized as not just mere intimidation, harassment, bribery, but fundamentally a 1.5 year long assault on the integrity of the trial process, on the integrity of the criminal justice process. It was well within Justice Mandelbaum's discretion to consider all of those factors.
What about the fact that this is a first offense?
So, Your Honor, the court could and did consider that factor, and in assessing whether a 12-year sentence for this offense is unduly harsh or severe, which is the statutory standard, this court can consider that the 12-year sentence was less than half what the statute allows. The defendant could have been sentenced up to 25 years. He was sentenced to 12. I think
it's true, but it's also double of what you wanted a plea bargain to.
It is. Well, the people offered 8, indicated a willingness.
I'm sorry, I thought it was 6.
But the people indicated a willingness to come down to 5 if the defendant made clear that he would accept it. So yes, it's more. But again, the trial record made clear a number of considerations that the court could and did consider, including the seriousness of the offense and its lasting impact. To answer a question that Your Honor asked earlier, the exposure on the counts other than the top counts. That's set out at footnote 2 of the People's Brief, page 9. The defendant the maximum was 1 1/3 to 4 years on the tampering with a witness count, 2 1/3 to 7 on the bribing a witness count, and 1 year on the criminal.
And that's what he got, 2 1/3 to 7 on the bribery count. Right?
Correct.
So had that been run consecutive,
correct,
there's a problem.
Correct. Yes. If I can address just very briefly the second ground for appeal, which Mr. Jackson's counsel did not raise, but which is the request that this court revisit the decision by a different justice to decline leave to appeal the denial of his post-judgment 44010 application. There's just no basis in the statute or otherwise for this court to consider that. The defendant is essentially requesting that the court entirely rewrite the statute and turn upside down the post-conviction review procedures. It would make the discretionary process a mandatory one. There's no basis for it.
Thank you.
Thank you.
Your Honors, I'll start by addressing just the sentencing issue again.
Okay.
The people were willing to come down to 5 years. That was the plea offer that was on the table. Mr. Jackson gets sentenced 12 years. That's almost 2.5 times what the offer was prior to trial. And every offer, the 5, the 6, 8, and 10, were below what the trial judge ended up sentencing Mr. Jackson to. Justice Mandelbaum's sentences have come before this court numerous times in the last few years, and time and again, this court has recognized that he has been sentencing defendants to longer than the interests of justice demand. There's been sentence reduction.
Counsel, have we said that in writing?
What you have said, Your
Or
Honors,
is that your understanding?
what you've said, Your Honors, is that in case after case involving Justice Mandelbaum, with defendants who were more serious offenders than Mr. Jackson, second-time felony offenders, second-time violent felony offenders, and in offenses that are more serious than the offense at issue here, kidnapping, child endangerment, repeated burglaries, sentences of up to 52 years that were cut to 32 years. Those are very serious sentences that became before this court, in which this court exercised its discretion to lower those sentences. If I may just briefly address the 460-15.
You have 30 seconds.
Thank you, Your Honor. We're not asking this court to exercise appellate review over the collateral motion, the 440-10 motion. We're asking this court to settle an issue of statutory construction about the meaning of 460.15.
The statute says what it says, and there's no ambiguity in that statute.
Understood, Your Honor. We believe this court has the authority to construe the statute.
To rewrite the statute?
Not to rewrite it, Your Honor.
That's what you're asking for. Your arguments are asking us to ignore the written language of the statute and substitute our own position for it. We are not permitted to do that. But I appreciate your argument. And again, I thank you for your pro bono service on this case. Thank you very much.
Thank you, Your Honors.
Wallik versus Wallik. You may proceed.
Good afternoon, Your Honor. May it please the court. My name is Kevin McDonough, and along with Sophie Spears, my associate, we represent the respondent appellant, Keith Wallik. The sole issue before this court is whether or not the videotape at issue, which was made as part of a joint investigation into my client by the New York City Police Department, the New York County District Attorney's Office, and Child Protective Services, constitutes a quote-unquote official record as provided for in Criminal Procedure Law, Section 16050.
So can we start with a discussion of Hines v. Krasik, 1978 case that was affirmed in 1979?
I didn't hear you. I didn't hear the beginning, Your Honor.
Sorry.
Okay.
I was saying, can we begin with a discussion of Hines v. Krasik, which was issued by this court in 1978 and affirmed in 1979, and it said, a tape recording made in the course of an investigation does not automatically become part of the official record required to be sealed under CPL 16050 simply because it is marked in evidence as an exhibit in the course of a criminal trial. So the investigation is routine by CAC. The recording is routine. The collaboration with the police and the DA's office is regularly done. Why is this case different?
Well, okay, so the fact that it's regularly done is irrelevant to this issue.
Forget the word regularly.
I'm sorry?
Just forget the word regularly. That's my adjective or adverb, whichever.
In this case, and ACS in their own briefs acknowledges that on many occasions the CAC procedure and interviews is not done with the New York Police Department or the District Attorney's Office. On many occasions, there's many interviews that are done, whether videotaped or otherwise. In this case, This case, this video was done as part of a police investigation between NYPD, the district attorney's office is there, CPS is there. They brought these children to be interviewed there. The police prepped the interviewer in advance of the interview. Throughout the interview, the social worker would step out of the meeting to confer and be directed by the NYPD and the district attorney's office.
You're assuming that they were directed. You can continue, but I'm just pointing that out.
Well, I frankly don't think I am. ACS acknowledges in their brief, the lower court acknowledged in its decision that repeatedly the social worker would step out of the room to confer with NYPD and the district attorney's office. They were directing this investigation. Again,
Counsel, the cases that you rely upon, the Willem case, the Ledbetter case, those all involve statements by a defendant to CPS workers or after the right to counsel had been had kicked in. And do you have any other cases outside of those particular cases, which I don't think apply here, they're distinguishable, that would support your argument?
Sure. So first of all, the statute clearly states it's all official records relating to the arrest or prosecution which are on file with any police agency or prosecutor's office shall be sealed. Okay? So it's not, the statute is not limited to interviews, videotapes of a potential
But
defendant.
Harper v. Angiolillo says that not all recordings of or documents are official records simply because they take place within the course of an investigation.
And there's no question about that. You could have documents, and the cases that they cite, which for that proposition, documents which predated an investigation, documents which were not directly relevant to the charge in the case.
Let's talk about recordings. Not all recordings are official records.
No, this court has held that not all recordings are official records.
Right.
This court has held that 9/1 tapes.
So why this record?
Because this record, this videotape, was made as part of the criminal investigation being conducted by the NYPD and the New York District Attorney's Office. And
Was there a criminal investigation underway?
1,000%. That's why they were there. This occurred on Friday at the Special Victims Unit uptown in Manhattan. NYPD was present. The district attorney was present.
But there's nothing odd with that, right? I mean, what the CAC does, it's multidisciplinary, right? And they routinely have law enforcement, psychologists, and a whole host of other people for the protection of the child.
And that's okay. But if these agencies, including the NYPD and the District Attorney's Office, choose to have the NYPD run that investigation and that video, it is sealed under 16050 if they then dismiss the case. No one
You're
forced it.
saying that they ran it because they conferred with them is not proof, but you'll have time on rebuttal.
Yes, Your Honor. Thank you.
Good afternoon, and may it please the court, Rebecca Viscatus for the Administration for Children's Services.
Can you respond to his last comment, which is NYPD ran this, so therefore it's an official record?
Sure, my response is that it doesn't matter if NYPD ran it or was involved in it, that this is not what CPL 16050 was designed to protect against. This court has recognized—
CSC, one of those entities that particular statute was aimed at when it comes to sealing.
Absolutely not. So, right, there are two related reasons why 16050 doesn't apply here. The first is what you just mentioned, that neither ACS nor Safe Horizon is a law enforcement entity that is specifically listed in the statute.
They have different functions.
Exactly. These are not agencies that maintain the records of someone's criminal prosecution. They are agencies that have their own directives and their own responsibilities.
But
In
this
case,
particular recording was used as a basis to further the criminal investigation, which was ultimately sealed. And the purpose of the sealing statute, right, would be presumably to not have such items out in the atmosphere being used in a different context when they couldn't be used in a criminal context.
the purpose of the sealing statute, as this court and the Court of Appeals and many other appellate courts have recognized, is to protect against the stigma that's associated with the fact of an arrest and prosecution. That is not implicated here. This is about the underlying allegations that defendant's children, or that the individual's children made against him. And the statute was never designed to insulate someone from any consequences of actions that they may have committed. That would run against sort of the whole way our legal system works. It's well settled that that individuals can face civil litigation related to criminal allegations that they were ultimately acquitted for.
Right, and if we were talking about this in the context of another criminal case, we might be having a different conversation, but that's not what we're presented with here.
Perhaps. I think that there are a lot of questions about the contours of this that are not brought up by this case. I think that this case is very simple because the agency that was seeking to use these records and the agency that created the records and maintained them in the first place, neither of them was covered by the statute. And these
I
records...
understand that this is multidisciplinary and you have a lot of different hats in the room. How do you respond to the if this was brought about by NYPD? This is NYPD's idea. They're the ones that are saying interview. These are the questions you need to ask. Are we in a different ballpark then?
No. I still think that really this entire theory of how much of this was directed by law enforcement is irrelevant. Appellant points to absolutely no authority for the fact that that would be the proper inquiry under 16050. But in any event, this is the CAC interdisciplinary process is something that is directed by the social services law. The legislature specifically laid this out, that the agencies are intended to work together to minimize the potential traumatic effect on a child of having to repeat their allegations multiple times to multiple different adults.
That's where I wanted to go. Well, we are talking within the context of a family court proceeding where child abuse is alleged. And my question would be, to what extent is there an interplay between the criminal procedure law and family court proceedings where the best interest of the child is at stake?
Right. I think that it's very important to remember that. And I think the fact that that the legislature wrote the social services law specifically contemplating that videos like this from the CAC would be available for child protective proceedings and other
It's not
court
just available.
proceedings.
It says that they shall be disclosed for the purpose of investigation, prosecution, and/or adjudication in any relevant court proceeding.
Exactly. Thank you, Your Honor. And the fact that the legislature wrote that and they are aware of the fact that these cases may proceed on different timelines, they're aware of the fact that there may be different outcomes in these, and they did not believe that it was necessary to address that interplay because they apparently saw no tension.
And videotaped interviews are covered under the statute, 423A, 5A of the social services law, right?
That's correct. They are specifically mentioned.
Thank you.
Thank you.
So, counsel, hi. The interplay between the criminal procedure law and family court proceedings, such as this one, which is a child abuse proceeding, where the best interests of the child are paramount. What do you have to say about that?
No one's stopping ACS from not prosecuting their neglect proceeding. That's not what we're talking about. There are rules in terms of the criminal.
You don't want ACS to use those interviews.
They can use other evidence that they have gathered if they have
The statute
it.
says that those videotaped interviews shall be disclosed.
That doesn't mean that they're admissible in evidence if they're generated by the New York City Police Department. Because
Why are they generated by the police department if they are taking place within the context of Safe Horizons and the CAC?
Well, then then I don't understand what the point of the CPL section saying it has to be sealed is. It's non-discretionary. It shall be sealed. The court
Are you
has
talking about 16050?
the what?
No.
Oh, I'm not sure if the court had another question.
I'll be sealed.
Your time is up, so let's round it up. I'll give you 30 more seconds.
Okay. Again, CPS can prosecute their case in the Article 10 with whatever other evidence they have. And as this court knows, there are different evidentiary rules related to hearsay and other things in child abuse and neglect cases. But that in no way, shape, or form changes the fact that this tape was prepared at the direction, with the assistance of, in the presence of the NYPD. And that's how this tape came about. This was Friday night. They arrested him. They left.
We understand. We know the facts. Thank you.
Thank you, Your Honor.
Don't worry.
Everybody got rebuttal? Oh, I wasn't here for that one. Really?